The matter of 257-261 20th Avenue Realty LLC versus Alessandro Roberto. May we please have appearances of counsel? Alessandro.
Good morning, Your Honor. Alonso from Golden Master Side on behalf of the petitioner. Good morning, Your Honor. Russell Finestein of Finestein and White, the New Jersey Land Title Association.
Okay, please, Your Honors. Good morning. Adam D. Rieger, Tony D. Rieger, Cherry Hill, on behalf of the National Taxing Association.
May it please the court, Your Honors. Len Reiser, from the law firm of Shapiro, Colin, Reiser, Appel, and Diorio, for the respondent.
Christina Martin, I'm Pacific Legal Science for Amicus. Right, variant and Sutherland on behalf of Amicus Legal Services. Assistant Attorney General Jean Riley on behalf of the state and supported by the department.
Ms. Riley, I'm sorry we couldn't find a seat for you at the table here, but we'll welcome you nonetheless. Justice Pierre-Louis is participating in this matter. She's going to be viewing the argument. Mr. Almanza, please go ahead.
Mr. Chief Justice, Associate Justices of the New Jersey Supreme Court, may it please the court. I'd like to reserve some time for rebuttal.
That's fine.
There are 3 or potentially 4 issues before the court in this case. The first has to do with Tyler, whether it applies to New Jersey's pre-amendment tax sale law. We contend it does not. The property right at interest in Tyler was one recognized at state law in Minnesota. It was the Minnesota legislature's abrogation of that right, the manipulation of the law that divested owners of that interest that caused the Supreme Court to conclude a taking had occurred. In contrast, New Jersey has not recognized that right historically. In fact, New Jersey never recognized that right until July 10th of this year, when the legislature passed A 3772 and enshrined property owners' rights to surplus equity in a tax foreclosure. Based on that fundamental difference alone, we believe the takings analysis below is flawed. The second issue before the court has to do with the state actor analysis. There's an established test for determining whether a party is a state actor. There are very limited circumstances. The decision under review does not employ the test. The test asks whether a party performs a traditional exclusive public function, whether it receives aid or assistance or encouragement from the state, whether it does so with the compulsion of the state, or whether it acts jointly with the state. None of those elements is satisfied. A private lien holder does not take any direction from a state actor. It does not act at the compulsion of a statute, and it does not act jointly. The third issue has to do with the panel's 450-1 analysis. We contend that it was an abuse of discretion to find exceptional circumstances in this matter. The facts found as exceptional circumstances include the forfeiture of equity in a tax foreclosed property. Now, until the legislature passed its amendments in July of this year, the forfeiture of equity in a tax foreclosed property was commonplace. In fact, it's expected. It's the expected outcome of the statute that vests fee title in a plaintiff, 54-587. So we contend that the effect of a statute as written cannot be the self-same basis upon which we vacate the judgment. The last issue before the court, which may or may not be before the court because certification was not granted as to this, has to do with retroactivity. Now, if the court disagrees with our position and concludes Tyler applies, then the court may reach the issue of retroactivity. In that case, we do agree that the panel's retroactivity analysis is accurate and thorough. It appropriately balances the 3 Kuhn's factors. In particular, first, that a new principle of law has been established. The panel was absolutely correct about that, assuming that they were right in the first place. The panel was also correct that there would be substantial inequitable results if there were fully retroactive application, because parties, both public and private, for roughly, well, at least since 1918, but before that really, since at least 1886, have relied on this law to foreclose tax liens and obtain fee title. It would be substantially inequitable to saddle all of these parties with liability, which would have an effect on, for example, municipal finance. With that, I welcome questions from the court.
Please go ahead, counsel.
You say that before the 2024 legislative amendment, there was no right to surplus equity in New Jersey. And you point back to the statute since 1886. But in Tyler, didn't the US Supreme Court specifically note that the principle that a government may not take more from a taxpayer than she owes has existed since at least 1215 with the Magna Carta and persisted in the early United States as, quote, the overwhelming consensus with few exceptions?
I recognize that, Your Honor, but I do not believe that that can be construed as imposing a nationwide property right, because that would be in violation of the Erie Doctrine. If you look at the Phillips versus Washington Legal Foundation case that I cite, also US Supreme Court case, they employ a similar analysis in that one where they reach back historically to ascertain the existence of a property right. They go back to the English legal system and say it has been part of the property right in that case, by the way, was interest on principle, interest follows principle. They say this derives from English common law, but it also was a feature of the forum states law, Texas. So when Texas went and changed its law to abrogate that right, that's the manipulation that causes the taking. Again, we've never had any statutory law or decisional authority in this state, so long as tax foreclosure law has existed, so far as my research reveals, that discloses that recognized property right.
Please.
When you refer to the manipulation by Minnesota law, the law was enacted in 1935, right?
That's correct.
Okay, and existed for almost 100 years until the US Supreme Court decision in Tyler.
That's correct, but it did overturn prior Minnesota statutory and common law that had recognized the right to surplus equity in a tax foreclosure.
But it then created a new statutory law that was the rule for almost 90 years.
That's correct.
Does New Jersey recognize and protect surplus equity in mortgage foreclosure matters?
It does.
So a bank cannot recover surplus equity beyond the delinquency in the mortgage payment.
That's
correct.
That's correct, Your Honor.
And why is that? What's the source for that?
The source is that this was a consensual transaction between a borrower and a lender for a fixed amount, and the borrower may not obtain more than it's justly due under the contract.
Is there a statute that underlies that as well? I'm thinking of 2A 50-37 in particular, which dates back to 1951 and says monies arising from a sale pursuant to this section relating to mortgage foreclosure shall be applied to pay off and discharge the monies ordered to be paid, and the surplus, if any, shall be deposited with the court, and the same shall be paid to the person or persons entitled thereto. If I've read that right and it says what it says, what does that tell us about New Jersey law and the property right to surplus equity?
I don't dispute, Your Honor, that different circumstances may treat the property interest differently. But what I do say is that context does matter. And let me briefly diverge to explain a little bit about why we have the system we have and why tax is treated differently than mortgage. In the 1800s, there was a municipal fiscal crisis. People weren't paying their taxes. There was an incarnation of the tax sale law that provided the cases had to go to juries. Juries would not give tax lien holders property based on tax delinquencies. That caused the implementation of the Martin Act. The Martin Act being the first incarnation that went from taking the hands out of a jury to making foreclosure strict. Foreclosure was always, as far as my research reveals, strict in that the judgment would vest fee simple title, free and clear of all interests. However, it was taken out of the hands of a jury and given a strict treatment based on the municipal fiscal crisis that occurred. People were not paying their taxes. Juries would not provide property to lien holders. And so the legislature needed a fix because there were municipalities that were on the verge of bankruptcy. That is the historical underpinnings of why we have the system we have. That is why we treat tax delinquencies differently than, for example, mortgage delinquencies.
But say a little bit more about the core reason for the difference. The owner of the property he has surplus equity in there. what is the principal distinction between the bank not being able to take that money, but a town or a private lien holder able to do so?
I believe that it may have had something to do with the fact that we need to attract and maintain investment in municipalities. If there is the prospect of gaining fee simple title to real estate, it makes the tax lien a more attractive investment opportunity, and it helps keep the municipal budgets balanced and stable.
If your case were decided under the new statute, would you have a constitutional claim? Because obviously the right is embedded in the statute, the right to surplus equity. So if your case were being adjudicated under that new statute, would you have a constitutional claim?
In other words, if the final judgment entered prior to the enactment of the law?
I'm not suggesting it's retroactive to your case, but if your judgment, if this case had been decided under the new statute, would you have an argument in the based on either a constitutional principle or on the statute?
Would the case arrive in the same procedural posture before the trial court in that there was a validly obtained final judgment?
Assume that.
Post-amendment. In that case, I believe under this court's precedence, a 450-1 motion would not suffice to vacate the judgment. There's a case called Hartford Insurance issued by this court in the, I believe it was the mid-60s. I don't have the site off the top of my head. That, for example, said a change in statute or case law post-judgment following the expiration of the time to appeal is not a sufficient basis to vacate a judgment under 450-1F. So
you would still have the 450-1 argument.
There would still be a 450-1 argument, but under this court's precedent, the change in law would not be a sufficient basis to vacate the judgment.
You were mentioning before that you think that the purpose behind this law is to balance municipal budgets and allow municipalities to collect property taxes. Doesn't that run straight into your argument that there is no state action here because this is a private purpose, there's no public purpose?
I don't believe so, Your Honor. So we ask whether the state involves itself in or assists in or encourages or compels the action. And the action we're discussing here is a tax foreclosure. Certainly, the municipality sells the lien. There's no question about that. But once the municipality sells the lien, its involvement is done. It's receiving a tax stream from the lien holder. And at that point, we have purely private action. Again, the private lien holder is not.
Doesn't the municipality calculate the redemption amount, receive and file affidavits of subsequent taxes, and process the redemptions? That all comes just from your petition.
That's correct. Those are ministerial tasks that the statute requires any tax collector to do, whether pre or post filing of the complaint. So really, it's not in any way bound up with the foreclosure itself. Because let's say a tax lien issues and then 3 months later, the property owner wants to redeem, they go to the tax collector and say, please give me a redemption calculation. The tax collector will do so. And then they tender the redemption.
But the New Jersey constitutional provision is broader, is it not? It includes individuals and private corporations.
I agree with that. And
so why doesn't that defeat your argument?
Because that was made for a particular purpose. And the particular purpose is back in 1844 when that was correct.
Yeah.
Private companies that are imbued with the power of eminent domain to make railroads, or the more modern incarnation under Gallatin, for example, the local housing redevelopment law.
That's not what, but that is not expressly stated in the constitutional provision, is it?
It's not expressly stated, but that was the purpose of that. In contrast,
when we look at a constitutional provision, we do look at the plain language of the provision. Am I right about that?
You can look at the plain language. You can also look at the circumstances surrounding the adoption of the principle. And I just don't think the circumstances surrounding the adoption of that principle really match, because the tax law does not contain a mechanism that imbues a lien holder with the power of eminent domain or anything like it.
Well, regardless of the circumstances of the adoption, I think Justice Patterson is pointing out that the framers of the Constitution could have chosen to frame it as private railroads shall not be authorized to take private property for public use without just compensation first made to the owners. But instead, it was written as individuals or private corporations shall not be authorized to take private property for public use without just compensation. So regardless of the context in which it arose, the framers perhaps understood that they were drafting a constitution for the ages, and that it wouldn't apply in only one circumstance. And they could have written it to apply only to railroads, but they seem to have affirmatively chosen not to do that.
I think that this is a square peg round hole situation, because I do not view tax foreclosure, and I don't think the law has historically viewed tax foreclosure in New Jersey as a taking. I think it has historically been viewed as a forfeiture, and forfeitures are treated differently from takings. I analogize in one of my briefs to, for example, adverse possession or administrative forfeiture or civil forfeiture. Not every time property is taken, whether by a government or a private actor, is it considered a taking for constitutional purposes.
But the U.S. Supreme Court has decided that it is. So even if you disagree with the U.S. Supreme Court's decision in Tyler, we do not have the authority to disagree with the U.S. Supreme Court's decision in Tyler. It interprets the federal Constitution in a way that we are required to uphold.
Understood, but I will revert to the prospect. While the court is certainly bound by that, the court, I do not believe, is bound by the U.S. Supreme Court's interpretation of Minnesota law. And again, that is a very big distinguishing feature here that was never touched on below, never grappled with. The law there is fundamentally different. And if the court had intended to undo Erie, it would have said so in plain language. But as constitutional law currently stands, I do not think that the Supreme Court announces federal general common law principles or rights that every state must accept if they have never accepted them.
We go back to your state actor position. You don't disagree, do you, that the collection of tax revenues is a traditional and exclusive public function?
I agree with that principle.
And is the private lien holder in this case, in essence, helping perform that role by trying to provide a stream of revenues for delinquent taxes?
I think it's a logical stretch to conclude that. There is a distinction between collection and enforcement. By the time a lien has been sold, that is the point where collection has failed. And at that point, we have the lien holder who is paying the taxes. The lien holder isn't collecting taxes, they are paying taxes.
Aren't the lien holder and the governmental entity collaborating in that regard?
They're not. There's no statute that provides for collaboration. It's no different than a property owner paying their taxes.
Could the lien holder act on its own to accomplish what has taken place in this case?
The lien holder does act on its own.
Without any involvement from the municipality?
The only involvement that a municipality has at any stage of the foreclosure is the tax collector signs an affidavit of non-redemption.
But it all starts though with a default on taxes. None of this happens unless there has been a failure to pay taxes by the property owner.
That's correct.
Correct? So what is obviously you have condemnation, which you would, I assume, concede does create a taking. And then on the other side of the spectrum, perhaps a situation where it's entirely private and there's really no government involvement. But what's the principle? Where is the dividing line between a state involvement that creates state actor status for purposes of takings and when it doesn't?
I think that the Lugar case, which the Pacific Legal Foundation cites, provides a pretty good example of when there is state action, when there's enough state action. But I also want to distinguish the case from the situation here. Lugar involved a Florida statute that described procedures for prejudgment, ex parte attachment of debtors' property. As part of that application, the sheriff would levy. This is ex parte and prejudgment. By doing so, there was sufficient intertwinement between the state and the private party.
Foreclosure and the foreclosure process involves the state.
It does not, Your Honor. The only involvement of the state may be at the writ of possession stage when the sheriff.
But isn't that analogous to what you were talking about in Lugar?
No, because number one, it's post-judgment, and number two, it's no different from mortgage foreclosure. So we would also have to conclude that mortgagees employing the foreclosure process are also state actors because they also resort to enforcement of a writ of possession through a sheriff.
So if the court were to state a principle as to what differentiates a taking versus a non-taking, and based upon the level of involvement by the state, what is that level? I know you gave us an example, but what is the principle that the court should apply?
I believe that the statute would have to invoke the aid or assistance of a governmental entity.
And this one does not, because all the governmental entity does is provide an affidavit?
That's correct. In the
Isn't
foreclosure
that aid or
process.
assistance? I mean, am I right that if no affidavit is forthcoming, nothing happens, correct?
Without an affidavit of non-redemption, you probably can't get a final judgment. But I also want to highlight that tax collectors also provide affidavits to property owners. When a property owner redeems a lien, the tax collector provides an affidavit, certificate of redemption. I don't think we treat property owners who receive certificates of redemption as state actors.
But there's no question of a taking in that setting, right? The person started out as the property owner and then they retain their property.
I'm sorry, Your Honor, I believe your question had to do with the level of involvement to qualify as a state actor.
As a state actor for purposes of deciding whether there's a taking. But in the situation you're talking about where the property owner does redeem, does keep the property, there's not going to be a taking, obviously.
There's no taking, but my point is that I don't think that we can conclude that there is state action merely because a tax collector signs an affidavit of non-redemption.
So does the state have to initiate the proceeding in order to have a state actor status?
I believe that yes, correct. I believe that the lien holder would have to be the state in order for there to be state action in a tax foreclosure. That's correct.
Early on in your argument, you pointed out that it was an abuse of discretion to vacate the final judgment under subsection F. I think you pointed out because the judge considered the significant equity in the property. Am I right?
Yes, that's correct.
What about the other points that the appellate division noted, such as the defendant escrowed the required funds into his attorney's trust account, certified that he had compounded financial hardship from tenants during COVID-19 related to rental arrears, and that the defendant was 75 years old and owned the property for over 20 years. Do those points come into play when determining whether under subsection F it's an abuse of discretion to vacate a final judgment?
I don't think any of those things are truly exceptional. These sorts of motions are reasonably common. Anytime a motion like this is made, the defendant necessarily must come before the court and display an ability and an intent to redeem. Because if they don't, then under the language from Guillaume that I cite, it's not really worth the court's time if they don't have a meritorious defense. Meritorious defense in this case being the ability to redeem. So without that prior showing, the motion is doomed to fail in the first place. But I don't think that putting up the money, having the money post-judgment alone, coupled with the forfeiture of equity is truly exceptional. It happens all the time. It has happened all the time. In fact, there have been published appellate division cases that say as much. Del Vecchio v. Hemberger, which is a published appellate division case, where there was an attempt to redeem only days after the entry of final judgment. And there was no doubt that the property owners had the financial means through a third party to redeem. But the court said, it's not good enough that you came up with the money too late because we have a statute, 54-587, that bars the right to redeem after a particular time.
3 months.
Well, the 3 months is, that's more of advisory based on this court's decisions. That part of that statute succumbs to 450-2 as far as the time and bases for vacating a judgment.
Doesn't the statute, though, 54:5-87 say no application shall be entertained to reopen the judgment after 3 months from the date thereof?
Absolutely, and I would love to argue that one, but I believe various courts have said that particular provision is subordinate to the time in 4:50-2. So
But here it was still met, correct?
it was either within or just slightly after the 3-month period.
I thought it was less than 2 months. I thought the appellate division said it was filed less than 2 months after the judgment was entered.
I believe it was within the time period, yes. But I also want to point out that that statute does not say that you get an automatic vacation of judgment within 3 months.
But it contemplates that an application to reopen can be filed within 3 months.
It can be filed at any time that's reasonable, even beyond 3 months. But
That's not what the statute says.
but the statute does not control, it's the court rule, it's 450-2 that controls the timing of motions to vacate final judgments.
Before we reach the end of your argument, I want you to expound a bit on the public use point that you made earlier. The underlying concept behind the tax sale law is to replace the stream, replace delinquent taxes with a stream of revenue. How is that not a public use? Is it a private use?
Okay, so I think that there's a conflation of use and a mechanism. And if you take a look at Kelo, Kelo actually mentions this in a footnote by, oh gosh, name's blanking.
It's all right.
The mechanics are not the same thing as the purpose. We have to keep those two things separate. Taxes are a mechanic, but it's not a purpose. The purpose,
The public use doctrine comes down to the mechanics? Is that what
No.
you're telling us?
No, and look, I realize the unusual situation I'm putting myself in that private takings are per se, void. But this goes back to the square peg round hole thing. We have a system that it's never been viewed this way until now. If the appellate division was right, there was no taking until May 25th of 2023. The system, it's the way it's been, the way it's always been. It's always been viewed as the tax collection ends, enforcement begins. And enforcement, and that is the foreclosure of a tax lien, is not a traditional exclusive public function. It's not. It's been done since the beginning by private parties. And I have to draw the distinction between collection and enforcement. There's a different chapter of Title 54 that's devoted to collection. This chapter, Chapter 5, is different. It's enforcement. So I think we're trying to shove this into a paradigm where we say, well, what's the public purpose here, when it was never meant to be viewed this way in the first place. But again, the collection of taxes is happening independent of the foreclosure. The foreclosure is its own thing that is enforcement.
You seem to fault the appellate division for, just creating some sort of new understanding all of a sudden last year. But wasn't it the U.S. Supreme Court's decision in Tyler that made clear that even though this had not been seen as a taking, it is one?
Oh, I don't actually, I apologize if it came off that way. I don't actually fault the appellate division for its interpretation. I think that the appellate division felt bound by the Tyler decision, but at the same time, the appellate division didn't grapple with the predicate question, which is, what's the property right? Where does it come from and has it existed? Does it exist in New Jersey? That's where I part company. Certainly the appellate division recognized that this was new law. They are absolutely correct about this, that this, again, if it applies, it unsettles a law that's been on the books in substantially unchanged form since 1886. And that in turn factors into the matters of retroactivity, one of the Kuhn's retroactivity factors.
You talked about there's no federal common law. Tyler doesn't constitute federal common law because that would violate Erie, because it's a substantive area of the law. Could a state by state common law create a right analogous to the right created in Tyler?
Yes, I agree. If it's part of a state's common law, then a legislative abrogation could constitute that sort of manipulation that is a taking.
And obviously the legislature can create that right, correct?
Absolutely. And in fact, we believe that the legislature, that is its province to create rights like this, and it did create the right
In this year.
this year. Correct.
Anything else you'd like to add, counsel?
The last thing I'd like to add is I just want the court to be aware of potential consequences of its decision in this case. There are presently 3 class actions pending. One of them, Venue in Cape May, is stayed pending outcome of this decision. The defendants in that case include the state. There are 2 other class actions, both federal, one of which the defendants are all municipalities. And there's a third one involving private lien holder defendants. The decision in this case is monumental in that it will have a significant effect on the viability of those cases.
Can you quantify the number of individuals, the number of matters that would be affected by those?
You mean apart from the class action or in the class action?
Class actions.
I can't identify the scope of the class because they haven't been certified yet. We don't have any idea about numbers. But again, the vitality of those cases depends in some measure upon this decision. Assuming that you conclude Tyler applies, then the issue of retroactivity is an important one.
You said you agree with the appellate division's decision on retroactivity, which the appellate division characterized as pipeline retroactivity, correct?
Correct.
But here there had been a final foreclosure that was then reopened, correct?
I agree with that.
So in your view of pipeline retroactivity, would that apply to any final foreclosure that now can be reopened?
No, I disagree with the proposition that filing a 450-1 motion can reopen a finalized case and put a case back into the pipeline for a couple reasons. One of which is you could file a 450-1 motion in any case. And if that's all it takes to get back in the pipeline, every case can be back in the pipeline.
But the appellate division seemed to think that that's what put this case within the holding of Tyler and back in the pipeline, no?
And that is
To agree with that, because you said you didn't petition for certification on that and you don't think it should be in the case. So if we abide by what the appellate division said, they seem to say this case falls within the pipeline because the foreclosure was subsequently reopened pursuant to Rule 450.
I agree with that. The case arrived at the appellate division in procedural posture of an order vacating a final judgment. I think that fits the definition of pipeline because pipeline is defined as anything yet to reach final judgment.
So the distinction you would draw is between cases like this where there was already a reopening of the final judgment under Rule 450-1 and cases where at the time the law changed, there were settled judgments that were not subject to any attack under 450-1.
I think this case is unique simply because the intervening precedent arrived during the pendency of the appeal.
So your point, sorry, is that it wasn't reopened because of Tyler. It was already reopened and then it was just hanging out open and then Tyler was decided.
So this would be a pipeline case. Yes, I agree with that proposition. Now, I want to distinguish a case where there was a final judgment where the time to appeal had expired and then Tyler came out. I do not think that under this court's precedents, a 450-1 motion to vacate based on Tyler is viable.
That's after Tyler. In other words, the concern you have is about cases where Tyler's decided and then a group of parties tried to file 450-1 motions. Then those would not be pipeline cases.
Those, as long as the time to appeal the final judgment has expired, I don't believe it's a pipeline case.
And if we accept your argument, what's the scope of cases that are out there that fall within where there may have been a judgment that was vacated prior to Tyler?
I believe that that's probably a highly discretionary call on the part of the general equity judges who would look at 450-2 and determine whether a motion was filed within a reasonable time. And this is, again, assuming that the court concludes Tyler applies and that it could somehow form the basis to vacate a judgment, which again, I disagree with.
I thought the question was more of just a factual one. Are there other cases where the foreclosure had been reopened, then Tyler was decided, and so then the foreclosure was open and then Tyler was decided? I thought that was the question.
Okay, so I'm unaware of any cases specifically in that procedural posture, but certainly there were a lot of foreclosures that were pending pre-final judgment at the time Tyler came down, and a lot that are still hanging around because of the difficulties we faced.
The class actions you mentioned, what are the allegations there and why are they potentially subject to this opinion?
Well, if the court reaches the retroactivity issue and concludes that pipeline retroactivity is correct, as far as I'm aware, all of the class actions involve allegations of final judgments that entered significantly pre-Tyler, where there was no appeal whatsoever, or the time to appeal had expired. In other words, all of the plaintiffs are not pipeline. None of those cases, none of those foreclosures were in the pipeline.
So you've asserted to us that this decision is monumental and will have a tremendous effect. And I was trying to probe that with our questions. It sounds like we don't have the answer.
About why it's monumental?
No.
Because
you can't tell us, and I'm not faulting you for this, but we don't know how many cases might be affected within the parameters that you've laid out.
I can't give you a number, no.
Okay.
But I can surmise that given there's roughly $70 million worth of liens every year, in $70 million worth of revenue into municipalities, we're talking about a lot of money, a lot of potential liability for municipalities.
I'm afraid that doesn't tell us what occurred when in the process based on your argument up until now.
If Your Honor is looking for the specifics about the class actions,
I was looking for backup for this
backup. No,
point that you made, and I think we're done with the point.
And future cases would be under the new law, right?
The new law applies to any foreclosure that has yet to reach final judgment as of the date of its entry.
So in terms of talking about in the future and how much how much income to the municipalities may be at issue, that's really impacted by the legislature's amendments, right?
Well, I believe the legislature did what it thought it needed to do to bring New Jersey's scheme into constitutionality with Tyler, into harmony with Tyler. I don't believe that none of the class actions relate to new foreclosures under the new statutory scheme.
No, but what you're saying is you're talking about the revenue stream, $70 million, et cetera, and how much is at stake for the municipalities. The future cases from 2025, for example, those are going to be under the new statute, correct?
That's correct. Even the ones that are pending are going to be under the new statute. Yes.
So I just wanted to follow up on that. You separately mentioned, I thought I heard, that there were many foreclosures that were pending, but pre-final judgment when Tyler was decided. Then they were put on hold.
Mhm.
Then there was the new statute. So all of those will now be governed by the new statute because the way you characterize them was that they were pending pre-final judgment. Is that correct?
That's correct. Yes, I agree.
Thank you.
You've advanced a number of arguments for why Tyler does not apply. And you just said the legislature did what it had to do in order to comply with Tyler. What exactly did it have to do as you understand the law?
I believe that the legislature has its own discretion and its own decision.
What did it have to do?
I don't think it was legally required to do anything. But I think given the spotlight that Tyler put on this particular area of law, that it determined it was time to change the process. We've had this process for a very long time.
So that's a policy determination.
It's a policy.
Your position is they could have left the existing tax sale law in place and all would have been fine.
It could have. That's correct. Mhm.
Thank you.
Thank you, Your Honors.
Mr. Finestein.
Thank you. If it may please the court. The primary concern of the New Jersey Land Title Association is the stability of real estate titles that are derived from tax foreclosures. Obviously, underlying the tax sale law is the need of municipalities to sell tax sale certificates to generate revenue. An investor is only going to purchase those tax sale certificates if he knows he's going to be repaid or he has recourse to the property. Chances are, following final judgment within a year, that investors are going to sell the property to a third party or attempt to sell it to a third party. he's going to do that, title has to be marketable and insurable. Otherwise, he's not going to be able to do that. At this point, in light of the Tyler case, this case, we have a very high litigation risk. The reason we have that is because the time period for attack is uncertain or indefinite if you could file a 450 motion under 1F as opposed to 1A, which is a 1-year time period.
So you're not talking here about future cases that are going to be decided under the amendments. You're talking about the group of cases as to which there's already been final judgment, and you're saying that tell me if I'm wrong, you're saying that the possibility of a later attack under 450-1 creates uncertainty of the title in that group of cases?
Well, as well as future cases. We're looking at present and future cases. The future cases, if we are going to insure title, if we have a brand new matter that just got tax foreclosed and the investor is selling the property, title's got to be insurable, so and marketable. So what's going to happen is if in a future case someone decides to file a 451F motion, they could upset the title that has been insured already.
But why, I'm not understanding. If there's a new statute, then what would be the basis of that? The challenge that the new statute is also unconstitutional? Is that what you're referring to?
No. If final judgment has been entered in an action and thereafter.
But Justice Patterson was asking about future cases
Yes.
and how the new legislation would apply to them. And you seem to say, no, future cases are still uncertain and the new legislation would not apply to them. Maybe we're just disagreeing as to what a future case is.
Okay, maybe I didn't understand the question, but if you have a final judgment entered in a case tomorrow, and a 451F motion is made by that homeowner subsequent to that, how long do they have to make a 450 motion?
Sorry, but if the final judgment were entered tomorrow, that would have already been governed by the new legislation, correct?
Yes.
So what would the basis be? Are you saying that the argument would be that the new legislation is still unconstitutional?
No, if they fail to assert substantial equity in the underlying case, and now final judgment has been entered, and someone has an afterthought and says, oh, I need to vacate the judgment, I should have asserted the defense of substantial equity. Under what mechanism are they making that assertion? Are they making a 450 motion under 451A, or are they making the assertion under 451F that they should have asserted substantial equity? Now that has become a recognized offense.
You're saying that if a property owner has the right to demand a sale under the new statute, but doesn't assert that right because they're not familiar with it or it's new, whatever reason, those are cases that potentially would be subject to uncertainty that would give rise to some title issues.
Especially in a default situation where no defense has been asserted, they didn't make a demand for a sheriff's sale.
But none of that is at issue here, right?
Not in Roberto per se. No, this is the association's wants to espouse its policy concerns about what happens if someone wanted to make a 451F motion as to substantial equity.
It's a fair point to raise, but it's not one we can address in this case, is it?
Well, Your Honor, I think depending on your holding and what you may say in that holding, it may influence how these things are viewed in the future by chancery judges when someone does make a 451F or 1A motion. We're trying to avoid substantial equity as a defense and being used in a 451F because of the time period is indefinite. So we're ensuring a title. We don't want a claim being made 2 years hence and attacking a title that's been transferred to a third-party purchaser.
Can I ask, do you disagree with counsel for petitioner about the correctness of the appellate division's decision on pipeline retroactivity?
I agree in part. I think there's some confusion actually, because I've spoke to many an attorney on this issue. What is exactly is pipeline retroactivity? Can you make a 450 motion today and bring that case into the pipeline or not? I don't think that was the intention of the decision, but that, I think it's ambiguous from the decision of the appellate division. Can you, yes,
Sorry, so you think that the appellate division decided that you could make a 450 motion only on the basis of Tyler, even to a closed foreclosure that had already reached final judgment, and that that would still be pipeline retroactivity because the basis of the 450 motion is Tyler?
no, we're concerned that that you should not be able to open up a closed case. So if there's a case that's closed prior to Tyler, you cannot make a 450 motion
You agree
to
with Mr.
vacate that
Almanza?
judgment. So I agree with Mr. Almanza on that point, yes.
And do you agree that with his view that because of the really extraordinary circumstances in this case where the 451-1 motion was made prior to Tyler, this is a pipeline case?
Yes. This was an open case, yes.
Thank you.
So as to, we also agree with Mr. Almanza that on a 451F motion, this was not an exceptional circumstance. Substantial equity is actually a common circumstance. We see it all the time. And again, we think the failure to assert substantial equity as a defense should be grounds under 451A, so that would limit the appeal period to, not appeal period, but the period of time to file a motion to a 1-year period, which would give more stability to real estate titles, because as it is, many title insurance companies right now are either unwilling or reluctant to insure titles that are derived from tax foreclosures.
You're referring here to the titles of the third-party purchaser. Am I right about that?
That's normally, a tax sale certificate holder who goes through the foreclosure will sometimes order title insurance and get a policy. The more common scenario, I'm sorry.
Yeah, but the group of titles you're worried about here is not just every title connected with this, because you have the original property owner's title, and then you have the third-party title after the foreclosure, right?
We're concerned with that
With the latter group.
the third-party purchase of the latter group who is purchased from the tax sale certificate holder, who has proceeded through final judgment.
Because the members of your organization are issuing title policies that really cover that group now, not it's
Yes.
past history what title policies were issued for the original property owner. Am I
Correct.
right about that?
Most title insurance companies used to have an exception in their policies for claims relating to an opening of a final judgment in tax foreclosure. But it was limited to a 1-year time period, so that if we would insure, the exception would be if a claim is made during the first year, we're not covering that. If it's after 1 year, then they would cover it.
How are the title companies dealing with the change in the law?
It's very unsettled right now. Some title insurance companies will not insure titles to tax foreclosures at all right now. Others are waiting to see what your decision is, to determine what kind of exception they can put in the policies, because they either don't insure, or they're going to have a broad exception for any claim made under a 450 motion. That's why I was saying if you limit it to an A motion, it's a 1-year time period. You go to F, well, what's a reasonable time period? The problem with a reasonable time period is it's indefinite, it's uncertain. And then so what do you do from an insurance risk point of view? Otherwise, remember, you're paying, if you get a title insurance policy, you are obligated, if it's not accepted from coverage, to defend the insured from claims like this. So the defense costs for a 450 claim exceeds the title insurance premium by a lot.
I understand the uncertainty on timing, but this case was brought under originally E and F granted under F. That's the case. That's the procedural posture of the case that came to us.
Yes.
And obviously there's a time, it's an indefinite time period there, but
Yeah, it definitely came under F. We do disagree, as I said, that this was not exceptional circumstance. We think the appellate division was wrong in that circumstance because it's a common circumstance. It's not exceptional.
Doesn't F have to be read in conjunction with 54:5-87's 3-month strict time limitation to vacate final judgments?
I think Mr. Almanza, I agree with his answer in that that statute is subject to the 450 time periods. So that you're not stuck to 3 months. If that is your question, you can.
You mean subordinated to, correct?
I'm sorry,
You mean subordinated to?
the statute?
That's what
I don't know
your,
if I would characterize it as subordinated, but it's subject to being able to file a 450 motion, notwithstanding it being more than 3 months.
and your colleague was referring to a prior court decision that had held that?
I'm sorry.
Your colleague was referring to a prior court decision that had held that?
Um,
That's what it-
yeah,
I
there,
thought I heard.
I can't cite to you any cases per se, but yes, that's the understanding that, and I know there are cases because I've cited them in the past, but you are subject to the 450 rule.
Maybe Mr. Almanza can clear that up on rebuttal.
Okay.
Go ahead. Anything else you'd like to touch on?
Yeah, again, I just want to kind of like maybe the parade of horribles here, but you have a purchaser of a piece of property from the tax certificate holder who was not involved with the tax foreclosure, wanting to be insured. He is often borrowing money in order to purchase that property. So you have an insured lender in those situations. How do you insure that purchaser and that lender if there's uncertainty as to the time period within which a 451F motion can be filed? We'd say we can't have an indefinite period because otherwise we can't insure those titles. So just to kind of maybe bring it down to a more granular level, I guess, if you were thinking about buying a home that has been tax foreclosed and you can't either obtain title insurance or there's an exception for coverage that for any claims that are made by the original owner, are you going to buy that piece of property? I think not. It's just too uncertain. If you're not covered by title insurance, you're not buying that property.
What would you expect to be the remedy in the Chancery Division if a sale was undone?
Well, if the sale is undone, arguably it would amount to a rescission. And
And if it's a rescission, they get their money back.
they would get their money back.
And they're
but-
no longer terribly concerned about the title.
Well, you've invested money in that property, you've been living in that property, you've gotten financing to possibly do improvements on that property, and then what happens? Then you're trying to recover all those funds. So you have two competing people trying to recover on a rescission. You have the underlying purchaser, the third-party purchaser, and you have his lender trying to get money back. And it gets even more complicated if that person has sold the property. I've been involved with cases where there's been ordered rescission, 2 transactions. So, if it's the second transaction, they're trying to recover from the first, they're trying to recover from the tax sale certificate holder. It's very complicated and it's not that easy to recover.
Stepping back from the precise legal argument, you're asking that we consider some of these equities, investment, reliance, in broad-based terms.
Yes.
But only on one side of the aisle. The surplus equity in this case amounted to how much?
I can't answer that. It was sizable.
Hundreds of thousands of dollars?
I believe so, but I can't. I don't.
And does that have any place in the analysis, as you understand it?
Not as to the stability of titles, as I've explained, no matter what the substantial equity is, we need certainty once the property does get conveyed out to a third party. And that's what we're trying to accomplish here. If the person has substantial equity, they can make that claim in the underlying foreclosure action and seek their substantial equity. We don't have any issue with that. We're looking at it after the fact, if there's final judgment has been entered, and we don't want the uncertainty of a 450 motion upsetting the title that has gone into a third-party purchaser and its lender.
Understood. Thank you, counsel.
Thank you.
Mr. Greenberg.
May it please the court, your honors, good morning. I'm not going to sit here and argue about Rule 450. For the most part, I'm very happy with all of our chancery judges statewide because they have the experience to deal with these things. I do have questions about the state actor and the participation issues. I'm going to start with some of the questions that Your Honor's already brought up. Justice Wayner, after you talked about the 3-month bar in the statute, I wish the plain language of that statute had any impact upon my practice. It doesn't, because we have cases such as Bergen Eastern versus Koss, New Shrewsbury was a case, M&D Associates versus Mandara. In all of these cases, the court said, we control the rules of our court. We grant comity to the statutes, but we decide the rules. So the 3-month bar in the past 30 years of my practice has meant nothing. The judges will do what they wish to do based upon that. It is what it is. With regard to marketable title, we cannot insure a tax property by the person who did the foreclosure. I argue a case here this coming December where my client got a property, but bought a property following a tax foreclosure by someone else. The judge vacated it. And now we're coming up here. And interestingly enough, that party who vacated it had gotten the property by way of a tax foreclosure, which is kind of interesting. But what's crazy about it, and Your Honor talked about rescission, Justice Patterson, there was no rescission there because my client wasn't a party to the case. So now that client has to bring another action against that seller for that same issue as well. Chief Justice, you talked about.
Does that prompt the seller to turn around and seek relief at that point?
It becomes a mess is what it does. And as Mr. Finstein talked about, 1-2 owners later, you now start branching out into litigation all over the place. It becomes an absolute mess. Literally, if you buy a property this afternoon at sheriff's sale, you get your deed in 2 weeks. You can get title insurance as an owner. If you get a tax foreclosure property today, you can't get title insurance, period. The only person that can get title insurance will be someone you may sell it to.
Because of uncertainty?
Absolutely. They do not want to defend against these motions.
And how, if at all, does this change in the statute impact that?
I think it helps quite a bit because it limits the ability of them to challenge it. When we talk about Rule 450, there's a big question about this equity here. There are many cases that say mere equity in the property is not by itself enough to vacate a foreclosure judgment. Bergen Eastern versus Koss involved a 73-year-old woman with a history of psychiatric hospitalizations, didn't understand what was going on, and she had every dime to pay it. When there is something else other than mere equity in the property, that applies. Again, I'm not going to gainsay the judge's decision here. That's not the NTLA's concern, but it should not by itself be the only factor that's there.
The appellate division didn't say it was the only factor. They pointed toward 2 other things: COVID, his age, owning the property for 20 years.
COVID's an intriguing factor. As far as age, this is a commercial property. He had multiple rental properties there.
Was it a mixed use?
Yes, there were stores, there was apartments. This is not his home. You know, it's so much different when you deal with somebody's home. Typically, and Mr. Reiser will tell you, when we have cases against each other and it's a homeowner, we usually work those out. We usually settle those because certainty is better for both sides in those situations. Mr. Chief Justice, you brought up mortgage foreclosures. If you go back to Myron Weinstein's treatise in the very beginning, mortgage foreclosure in the beginning of time, hundreds of years ago, there were no sheriff sales. It was a strict foreclosure. That's why in other states they call it a deed of trust, because when you borrow money, you put the deed in trust with the bank. And if you didn't pay it, they owned it. And then they created the equity of redemption to do away with the harshness of the bank taking your property. I think I remember, if I remember correctly, in the 70s, Mr. Brady got the mortgage and they burned it because that was showing that they owned their house. So what happened is, over time, equity changed to create the equity of redemption.
Mr. Brady of the Brady Bunch?
Yes, absolutely.
I've never heard him cited in this courtroom before.
Why not?
Why not?
He never said anything wrong, did he? But how did an architect only have 1 bathroom for 6 kids? But it shows you the development of the law with regard to mortgages. So yes, in 1950 something, 2A50 came in, and there's surplus money in mortgage foreclosures. It was not always the case.
But it's been the case for a half century. What does that tell us?
It tells us that in mortgage foreclosures, that's what the legislature did. But they didn't do that in tax foreclosures. And this court said, it is therefore reasonable that tax foreclosure is a strict foreclosure. This court has no separate tax policy. That's what it said, I believe, in Simon versus Cronicker. The law has changed, so we don't have to even go too far with that. But that is what the legislature decided for many years. The tax sale law was with us since 1918, and it was upheld many a time. If it needed some tweaks, this court gave it tweaks. It dealt with Mullane, certified mails, all the different notices. This court adapted the law as necessary, but continued to carry it along. An interesting point, Justice Weiner, after you talked about Tyler and whether or not we're bound by it. Tyler was a governmental taking. It was not a private party taking. And I think that's a very big difference here.
But the Supreme Court vacated and remanded in a different case after Tyler that was a private party, correct?
Correct, Fair versus Nebraska. But they didn't do it with a decision. They said we remand in consideration of that.
Correct, but they don't do that if they think that it has absolutely no connection whatsoever. They didn't grant, vacate, and remand, for example, cases that had nothing to do with foreclosures or a possible taking. They only do that. They're only vacating and remanding in cases that they think might be impacted, might arguably be impacted by Tyler, correct?
Certainly might be, but that's for the lower court to make their record. One of the concerns I have here is the trial court.
The lower court there did hold that that was a taking and that Tyler applied, correct?
It did, yes, but again, in Nebraska, they have a tax deed. The government issues you, Tyler involved a governmental foreclosure. It was governmental action doing the foreclosure. In Nebraska, they issued a tax deed. You would make an application and the county would issue you a deed. No foreclosure, no nothing. Here, you own the property. Here's your deed, which is far different from what we have in New Jersey. As my colleagues at Pacific Legal talk about, they have joint participation, acting in concert. What do our tax collectors do here? They have a public auction. You buy it at the public auction. You buy the lien at the public auction. The municipality never has any involvement in it again whatsoever. Now, if you pay taxes, sure, you file an affidavit with the tax collector, great. If I file a certification with the court in a legal matter, that doesn't mean the court's taking action with me or for me. It's simply a ministerial fact that they're recording the fact that I made that payment. The tax collector, the mayor, the council, they don't tell me when to foreclose. It's completely a private entity that makes that decision. So when you look at some of the cases cited, Fuentes versus Shevin, Lugar versus Edmondson, first they were due process cases. As you see in my brief, tax foreclosures have more due process than any case anywhere in any of our courts. But not only were they due process cases, they were huge in joint participation. In one of them, they sent the constable out and they took the kids' toys, ex parte state action. That is not what we have here. At no point was there any state action. If I buy a property at sheriff's sale today, that's not state action. Tomorrow I own it. And if I file an eviction action, that's still not state action. So what if we have the Uniform Commercial Code? What if I have a car and I don't pay it? And somebody pulls up with a tow truck and takes my property, takes the car, they repossess it. Is that state action simply because there's a statute that says they can do it? Simply because they codified the right in the contract to repossess my car?
What's your position as to the New Jersey constitutional provision, which deals with individuals and private corporations?
Well, as pointed out, that was dealing with eminent domain. And when we have eminent domain, the assignment judge appoints 3 commissioners. They have a hearing. First, they get to decide whether or not it was right to take it. Then they decide upon the value. Then you get a jury trial. So you can't just take their property without due process and without just compensation. So both under the 5th Amendment and under the state constitution, that's fully protected. Eminent domain is a far different animal than what we're looking at. But turning to the repossession issue.
We go back to your car example.
Yes.
Because in that situation, you've got the retailer attempting to collect its property back. In this context, what role, if any, does the fact that municipalities, that governments are getting a stream of revenue to replace the delinquent taxes play? Because that's different than the car example.
Well, I would say to you, almost none. Now, first of all, I would just point out that this court decided the auto repossession issue 50 years and two weeks ago, called King versus South Jersey National Bank, 66 New Jersey 161. And it said mere codification of a right does not make it state action. This is not where the constable came and took their car. It was,
But what I'm suggesting is that there's more than just mere codification, because the state is benefiting from that stream of revenue. How does that play into the analysis?
I don't think it does, because all they did was have a tax sale. They had a public auction where people went and bid. They didn't do anything else beyond that. With regard to the enforcement of it, they had nothing to do with that whatsoever. They do nothing until they get a final judgment and the tax assessor marks down a new owner of the property. Let's say the New Jersey EDA had a mortgage and they sold the mortgage to a private party and that party did a foreclosure. There's no state action there. You know, yes, the state got money because they loaned that money there. They did, for some reason, they felt it was right to make that loan. Redevelopment, who knows? But it's not state action. This is not the constable or the sheriff going out and taking someone's property. This tax collector has no idea what's going on. They don't care what's going on. Literally speaking, all they do is some ministerial acts of they sell the certificate and then their hands are clean with it. There's nothing else more going on. So, you know, again, the tax collector doesn't say, hey, Mr. lien holder, you should start your foreclosure now. They don't care. The whole point of the tax sale law is to bring money into municipal coffers without making the government get involved in foreclosures. I can tell you in Camden, where my alma mater is, we have tens, if not hundreds of millions of liens going back 20 years or more because they don't have the money to foreclose them. You know, it's difficult, but it's frustrating without a doubt, but the government has nothing to do with it because you know what? The mayor doesn't want to be the one that says, we're going to take this person's property. So, and there's, other than the collection of the tax, there is no other public use here. If the sheriff takes money from a sheriff's sale, it's not a public use. Okay, so they get a commission on it, that's fine.
But if there was no public use, then wouldn't it just be impermissible? I thought that your colleague, Mr. Almanza, had agreed that if there was really no public use at all, and if it was just equity that was not returned in a purely private context, that wouldn't be permitted.
I'm not sure I understand that.
So, for example, in a mortgage foreclosure, the bank only gets to keep the amount they were owed, correct?
Correct.
Okay. And so here, if there was no public use and it had absolutely nothing to do with the government, wouldn't the law just be that it was conversion or something if you're trying to keep more than you are owed?
Well, I disagree because there were statutes involved. In the mortgage foreclosure, we have 2A50 that specifically created that right. In tax foreclosure, and again, this court specifically said it's understandable that the legislature chose strict foreclosure. We've now changed.
Correct, but that was understanding the public policy of municipalities needing to collect taxes, which again is a public purpose, correct?
It's a public purpose at the outset to collect taxes. But to take step number 1 and imbue that with step number 5, 6, 7, and 8 is, I think, going too far.
So the debate is just what level of generality you're looking at the scheme. And you're saying that we should look only at the very end of it and say there's no state involvement at that point and there's no public purpose versus, for example, your adversaries who might be saying the entire scheme is about municipal tax revenues and wanting municipalities to be able to collect taxes. And that, therefore, that is a public purpose that is animating the entire scheme.
Well, and I forget, I apologize. One of your honors said, where's the dividing line? I don't know the issue, but I think when you need to have some joint participation, there needs to be more than one little thing at the beginning. There needs to be something that involves the state that makes it state action. And I don't think simply one tax sale 3-4 years ago, or in this case, 10 years prior, this person didn't pay taxes for 10 years. It started with a sewer lien and then led up to 10 years.
What about the fact that you go nowhere without that affidavit from the municipality about the status of the tax payments?
So it's sheerly ministerial. 54.5-98 says no foreclosure is entered unless proof is given that taxes have been brought current. So the collector signs a certification.
But aren't there governmental functions that could be dismissed as ministerial in terms of how complicated they are that create state action?
There certainly could be a sliding scale, but in this particular situation, the tax collector is ordered by the court to certify whether or not the certificate had been redeemed. And all they do is say yes or no. They have no discretion. This is not a discretionary decision on behalf of the government. They are making no decision, conscious or otherwise, to do something or not to do something. They were told, certify to the court whether or not the certificate has been redeemed. No more, no less. And I don't think that's state action here. So I think those are very important things to look at in those particular regards here. I think I've hit my point. Oh, pipeline. Mr. Chief Justice, you talked about the differences here. I have one client of mine indicated to me that, first of all, pipeline, they're talking about liability going back 6 years, not 2 years, 6 years. I have one client who says he foreclosed on 150 properties over the course of the last 6 years. He lost money on 40 of them, but he faces potential lawsuits on 140 of them. We have lawsuits, one in Cape May against the governor, as if the governor has anything to do with municipal tax collection. We have one in federal court going after tax collectors. Now, everybody's pointing the finger different ways. They certainly are in Nebraska. With all due respect to the state, they're pointing the finger at us. You know, everybody's trying to figure out who has to pay. And there's another one in federal court against a lien holder. And everybody's trying to figure out, do we third party everybody else in on these things?
And that turns on whether final judgments can be reopened in light of Tyler.
No, I don't think final judgment, that's not the issue of reopening final judgments. My position is if final judgment was entered before Tyler, it's not in the pipeline. But if retroactivity is allowed, then it opens up a flood of potential lawsuits for over the past 6 years for claimed loss of equity. And the inequities.
Does that differentiate your position from the position of counsel for the purchaser here, who I believe said that this case is pipeline, even though Tyler came after the final judgment was reopened?
Well, this case is pipeline because it was open. The judgment was vacated at the time Tyler came down.
Okay.
So it was certainly in litigation. I think any case that's on appeal, even if it got denied, it's still pipeline because the issue is in limbo, it's in litigation. But
You're talking about cases where somebody takes a look at this and says, Tyler seems to have changed the status of the law. Therefore, I'm going to reopen after Tyler. I'm going to file a motion under Rule 450-1 and try to reopen. That's the cases you say should not be included. Am I right?
somewhat, yes. I'm less fearful of a
Better
450.
than I normally do.
I'm less fearful of a 450 motion 2 years down the road than I am with a class action lawsuit for a takings claim. Because one, I fight before a judge. Do I win? Do I lose? If they get the property back, it gets worked out somehow. If with a takings claim, we have no idea what they get. So for example, I have one now where they're like, oh, well, you sold the property for $180,000. I'm like, yeah, but you have no idea what my client put in the property. On Tyler, she owed a mortgage, she owed a tax certificate, she owed condo. We don't know what the county spent on lawyers. We don't know what the county spent to fix it up. We don't know what they spent on realtors. We don't know what loss there really was.
But the Supreme Court remanded for her to get whatever equity was still there. Aren't you disagreeing with the US Supreme Court?
No, because that was a governmental taking. In that particular situation, it was the county that did the foreclosure. The question of
I thought you were talking about retroactivity. So in Tyler itself, they did not undo the foreclosure. Instead, they sent it back for her to get cash in whatever equity she was owed, correct?
Correct. And I was pointing out the difficulty of quantifying damages in those situations. Because
Understood, but recognizing that is what the Supreme Court required.
yes, in that situation, which again was a governmental taking. It was not a private taking. And that is a huge difference because it involved state action. Hennepin County decided if or when they were going to foreclose. And then once they got it, they sold that property.
I understand you're making that distinction.
You also run into situations where what if the government forecloses on it and it's just an unbuildable lot? They don't sell it. Then what do we fight over the equity?
I'm afraid we need to reach the end of your argument. Is there anything you wanted to end with on this point?
There is not. If there's any questions, I'm happy to answer them.
Thank you very much.
I appreciate the opportunity.
Mr. Reiser.
May it please the court. I just want to start with the fact that pre-Tyler, Rule 4:50-1 always existed for clients like mine who could come in front of a chancellor and petition the chancellor to vacate a judgment on grounds that are just as the preamble to Rule 4:50-1 indicates, and especially subsection F for any other reason that's available. That's been known as the catch-all provision. And that is exactly what my client availed himself of in this case. We didn't need Tyler. Tyler, it was a great bonus, but we didn't need Tyler. And the Chancery judge didn't have Tyler. And he went through and did an exercise of all of the equities that supported vacating the judgment. And I'll touch upon that in a moment. In this particular case, there are two goals actually of the tax sale law, and they were both met here. One was to promote the sale of tax sale certificates and collection of revenue. And the second one, as the Simon versus Cronicker case says, is to allow the homeowner to redeem. And both of those goals were met here. It wasn't enough for this particular plaintiff to get the benefit of its investment, which was 18%. No, that wasn't satisfactory to them. They came after my client's equity. And as Judge Facial pointed out, it was over $400,000. We had a comparative market analysis in the record. It said the property was worth between $475,000 and $535,000. It was undisputed. And I believe, as Mr. Greenberg just mentioned, the original tax sale certificate started out with nominal sewer liens of $606 that were foreclosed 10 years later. The constitutional issues that were raised here, my client didn't necessarily need to rely on them, but the fact that now the court, the Supreme Court, as Justice Wayne Raptor indicated, the Supreme Court has said that this is an issue, whether it's a governmental unit or not. Conceptually speaking, the concept that somebody could lose their property in a tax foreclosure suit that has substantial equity in it, unlike a mortgage foreclosure action, Chief Justice Rabner, you indicated, there has to be a sheriff's sale. Here, there is no sheriff's sale. And those factors are significant. And the law is not justified in making a distinction here by allowing a property owner to lose his property simply because there's no sheriff's sale and no final warning gets delivered to him. The title impacts, quite frankly, the case is monumental, but none of the title issues are impacting my client. What's monumental here is the potential loss that my client had when he came to my doorstep. And I'll also indicate here that there's an impractical aspect of the reinstating this judgment, because now we're 2.5 years out from it. What about the improvements my client has made to the property? There was no stay that was sought by this plaintiff. So the train started going down the tracks, the judge entered his order, and now we are here 2.5 years later, and the plaintiff is still not satisfied with its investment. It still is after my client's property. And I respectfully submit that had Judge Kioka not vacated this judgment, that would have been an abuse of discretion. So now I want to just touch upon some of the facts that got us here. First of all, I think I alluded to them earlier. This was a de minimis tax sale that started out at $606. The foreclosure case was filed not within 2 years. There's a 2-year waiting period for a case like this. They waited 10 years. Why? I think they did it on purpose, quite frankly. I have no proof of it, but I think that they waited until the lien got to be so substantial that it would become difficult for the homeowner, for the property owner to exercise its redemption. And the fact that this is a commercial property and not a residential property is a distinction without a difference. My client certified in the court below that this was a substantial asset for his retirement. So the fact that it was a commercial property is a distinction without a difference. The equity is equity, and it was just as important to him. So they filed the case in June of 2021 after 10 years, and they issue an order of redemption in October of 2021. And my client certified at that point. We were in the pandemic. He tried to get the rents, tried to collect rents from his tenants. He couldn't get the rents from his tenants, and that impacted his ability to cure. And if we all can think back to the pandemic, I mean, there was a lot of chaos going on at that time. Governor Murphy had issued orders establishing emergency procedures, put a moratorium on foreclosures, put a moratorium on residential evictions. My client, the fact that he was a commercial owner of property, was in no better position than anyone else. And COVID certainly impacted his ability to collect the rent. Some of the other important facts here that my client indicated in his certification: English was not his, he did not have a strong command of the English language. He was unfamiliar with tax laws. And I've been doing this a long time. Most people in that situation don't understand that there is no ability to have a sheriff's sale under that statute, that they could lose their property merely because a judgment was entered. He also indicated he put $2,000 of repairs into the property while it was actually in the midst of the foreclosure. He also indicated he was 75 years old. Now he's 77 years old.
So counsel,
Yes, Justice.
what about the trial court's findings under 1F are truly exceptional? There's the court pointed to the significant disparity, money in escrow, the timely motion, and there is a reference to COVID, although it doesn't seem quite as clear as we've heard. I thought the trial court said that COVID may or may not have had an impact.
It did.
And the reference to the age. What about any of those are exceptional circumstances?
Well, Your Honor, if we look at the totality of the circumstances, they are exceptional in the sense that he tried to redeem in that time period and couldn't get the funds necessary.
He brought $9,000 and
he brought $9,000 to the tax. He went down to the tax collector's office, right, with $9,000 and was rejected because it wasn't sufficient.
Is that uncommon?
I don't know if it's uncommon.
Is it
I
exceptional?
think it's probably someone who thought he owed a certain amount and went down there and found out it was much more than he thought. It probably was confusing to him because there were 3 separate tax liens.
So tell us what's exceptional about this case.
So what's exceptional, Chief Justice Rabner, is the fact that a combination of multiple things, as the appellate judge indicated. One was the fact that my client remained in possession of the property, which was critical. He never relinquished possession. It wasn't sold to a bona fide purchaser. That was also an important factor that Judge Kioka mentioned in his oral decision. The fact that my client, and I've never seen a case like this, probably because where my client deposited the full amount of redemption before we even filed the motion, I respectfully submit that is exceptional. The fact that he wasn't coming to the court and asking the court, well, I need another 60 days, I need another 90 days, I need another 120 days. No, he came to court showing that he was ready, willing, and able to redeem. And I respectfully submit that is substantial and makes this case exceptional. None of the other reported decisions that I've seen in the appellate court or any other court talk about someone who came in like my client did and actually put all the money in escrow before filing the motion. So the fact that there was substantial equity in this property is an exceptional circumstance, and it was proven true when Tyler came out and was published. So
I'll clarify one thing for us. You mentioned the $606 in the utility bills that went unpaid, the 3 bills. That turned into $33,000 by virtue of additional interest and fees tacked on, or were there additional bills that were unpaid?
So yeah, Chief Justice Roberts, so how it works, my understanding is that when they paid
additional tax bills unpaid,
the initial sewer bill were unpaid, and then
those 3, were there additional bills that were unpaid?
Yes, all the subsequent tax years, 2011, 2012, 2013, because I presume all the bills, once the plaintiff purchased the tax sale certificates, all the bills go to them. So that's my understanding. So that's how it ballooned over between the subsequent advances, which they're entitled to 18% statutory interest, and the continued payment of those additional tax amounts.
I'm confused. It had said in the record that there was, I thought, 3 separate bills that were unpaid, 2 in 2010 and 1 in 2016.
That's
You're
correct.
saying that no tax bills were ever paid, including in 2011, 12, 13, 14, 15, 16, 17. And is that what you're saying?
I believe that the plaintiff, yes, the plaintiff advanced those taxes for all those years. That's undisputed. That's how it got to the 32,000, is my understanding. In other words, it started out at $606, and then they advanced the taxes over the next 11 or 12 years. And it got to, by the time we went to redeem, ultimately, after the judge made his decision, it actually was $44,000 and change that we
So
actually
your
paid.
client never paid taxes after 2010?
I don't believe he did. No, he did not, because he probably didn't get a bill.
The total amount of money that in tax payments that he did not pay was?
The amount of the redemption, Your Honor, or is that what you're asking?
I'm looking for how many times, what the total of the tax bills that he received and didn't pay amounts to.
It came out to, I could tell you in 1 second.
Is that the $32,973?
It became about $45,000 when we actually exercised the right of redemption post judgment. we had to obtain payoffs from the city of Patterson. And that's where, if I can now, if you're on, if I can segue, I'm sorry, go ahead.
And is that fees and interest, or is that the taxes that went unpaid?
It was unpaid taxes, accrued interest, penalties. It was all based on redemption worksheets that the city of Patterson had provided to my office. And it was about $45,000. I can give you the
Counselor,
exact amount if you want.
can I just ask one quick question on this issue? What precisely is exceptional about what you might expect, which is in order for somebody to redeem and to have the redemption accomplished, they have to come up with the money. So is it so unusual in this practice area that it makes this particular circumstance exceptional that somebody would have all of it to pay?
Yes, I think that is. Yes, Judge Noriega, I believe that it does, because it almost never happens. I mean, and if it does happen, it's usually through a sale to a tax raider, as they'll call them, as happened in the Simon versus Cronicker case. And this case actually that we're here on today to try to answer your question, this case represents a logical extension of Simon versus Cronicker, because in that case, we had a homeowner and the court was, I think, with opinion written by Justice Albin, the court went to great lengths to protect the property owner in that case, in a situation where the property owner negotiated a deal with a tax raider and was going to get some money. Instead of losing all of it, was going to get about $60,000 or $70,000 worth of equity. And the court in that scenario, based on the objections from the tax sale certificate, the court said, we're going to protect the homeowner. We're going to allow the homeowner to get the benefit of that, but we're going to put a constructive trust on so that the tax lien holder could get the benefit of that same deal if they wanted. Here, we have the defendant himself, without going through a sale, without seeking any other third-party financing, put the money up himself. And that's, in my respectful opinion, is a logical extension of Simon versus Cronicker, when the homeowner, not a third party, comes in front of the court and wants to exercise his right of redemption.
Does your argument prove too much, following on Justice Noriega's question? Because in order for your client to win, he has to be able to come forward with the money. And by putting in an escrow, that establishes exceptional circumstances?
Well, it's a factor, Your Honor. Yes, it's a factor. And it is factored in with all the other circumstances that the Chancery judge had mentioned. The fact that the motion was filed within a reasonable period of time. I believe Justice Facial had asked when the motion was filed. It was filed actually within 2 months. So that was a factor. There was another factor that the judge had mentioned. There was no surrender of possession. My client remained in possession. There was no sale to a third bona fide purchaser. The property had represented all the significant retirement asset to him. So all of these factors, it was the totality of the circumstances, not just the mere fact that he put up the money. It was the totality of those circumstances combined together that created the exceptional circumstances that justified relief under subsection F. And I do.
Counsel, I'm sorry to interrupt you, but we're about halfway through your argument and we haven't addressed any of the thorny legal issues. Do you want to turn to them?
The constitutional issues? Yes. I certainly will, Your Honor. So let me start by addressing the issue about the state action. There's a litany of processes that a municipality must go through in order to aid, I guess, a private plaintiff in this instance. And I've got a good list here, which really hasn't really been touched upon by my adversary. First of all, the complaint requires a pre-action notice be sent to the Patterson tax collector. In fact, the complaint has to make that allegation. And the current amount due has to be obtained from the Patterson tax collector.
Well, let me pause you there. I know we're only on your first item, but there are many types of cases in which the state or an entity of the state have to be provided notice. Are you contending that is an argument for state action in those cases?
No, what I'm saying, Justice Patterson, is that it is part of they claim it's ministerial.
They don't even have to do anything. They just have to receive notice.
That's correct.
What's your second one?
So the other one is Rule 4:64-6B indicates that notice of the action must be filed with the tax collector's office, and that redemption has to be ordered to the tax collector's office. Okay, then we go in, if the redemption is not made, the tax collector has to file an affidavit with the clerk setting forth the redemption date. Then we look at NJSA 54.5.
Well, let me pause you again, because if redemption happens, we don't have a lawsuit, right? We don't have a foreclosure.
That's correct.
So again, we're talking about what constitutes state action that brings about a taking. And if redemption happens, the property owner retains the property.
This is all a part of the joint action aspects of it. So to answer your question, Justice Patterson, so the tax collector's office is not just a ministerial
We're talking,
provider.
I think what needs to be focused on is what is the state's role in going through to a foreclosure? So if there's a redemption, there's no foreclosure. So what is the state doing that brings about the foreclosure?
The state, so when they sell the tax sale certificates, that would be the first step. They have to sell the certificate first of all, and they remain involved in the process. I believe, as Chief Justice Rabner indicated, they remain involved in this process each and every step along the way. And I'll try to translate it into the actions that I had to take. When we got the judgment vacated, I had to obtain the redemption figures from the city of Paterson. Then when the redemption figures came in, the funds were delivered to the city of Paterson. Then the statute requires that the city of Paterson provides notice to the lien holder that they've received the funds, and then they will only deliver the funds to the plaintiff when the plaintiff provides the tax cancellation certificates endorsed for cancellation.
Because
So
aren't these simply safeguards that are put into place to make sure that the process is abided by? And it's not necessarily any interest that the state or the county has in the outcome.
well, you could look at it that way, Your Honor, but if we look at every step of the foreclosure process, even the redemption order itself, okay, and this order was no different in this case, it directed my client to go to the city of Paterson tax collector and pay the redemption. Even the final judgment that ultimately was entered references the fact that the affidavit of a tax collector had to be filed. So to sort of allude back to Chief Justice Rabner's question, that there wouldn't be no final judgment but for the tax collector signing that affidavit. And as the appellate division aptly pointed out, the municipality can't do indirectly what is prohibited from doing directly. And that's exactly what has happened here. I mean, the state constitution says that no taking shall occur without just compensation, nor shall a private individual or corporation be allowed to take private property without just compensation. So by delegating those functions, the municipality to the private tax collector, they're allowing it to happen. And that's really what the appellate division said. They looked at the fact that there was this joint actor aspect to this. And I've just recited all of these conditions that substantiate the joint actor aspect. This is even more substantial than it was in the Nebraska Supreme Court case, where the Nebraska Supreme Court seemed to be focusing on the fact that, well, you sold the tax sale certificate, and that constitutes state action. And I'm not saying that act alone is state action, but when you combine it with all of the other steps that have to be taken here that require the tax collector's direct involvement, it's exactly what the appellate division. And they got it right. They said that this is an exercise that violates the state constitution in addition to the U.S. Constitution. You know, and I also want to mention here that I don't think I wanted to mention this earlier, that in this particular case, my client's property still is encumbered. The plaintiff filed an appellate lis pendens that apparently is permitted under NJSA 2A 15-14. So as we sit here today, for the last 2.5 years, my client's property is still encumbered by this plaintiff's tax sale foreclosure, even though the judgment has been vacated. And I also want to point out here, and I think maybe Chief Justice Rabner might have alluded to this earlier. You know, in the foreclosure process, if a defendant pays off a foreclosure judgment, he gets a warrant to satisfy judgment under NJSA 2A 50-32. Why should it be any different here? In fact, in a mortgage foreclosure matter, as the Hardiston case says, under Rule 4:65-5, even after a sheriff's sale, a property owner can redeem his mortgage and save his property within 10 days. Why is that? Why doesn't the defendant in a tax foreclosure have that same opportunity? It's unfair. It's unconscionable in this particular instance. And I think this is really what drove Judge Keoka's decision. When you look at it in its totality, it's unconscionable that someone should lose their property with $400,000 worth of equity over a de minimis, what started out as a de minimis $606 sewer lien. It's just unconscionable. It's unfair. And that concept has always existed in our jurisprudence even before Tyler. And in the mortgage foreclosure aspect.
But the significance of Tyler is that it found a taking, obviously in a different setting. It found an unconstitutional taking. Are you making an unconscionability argument that is distinct from your constitutional claim?
I'm making that the unconscionability argument, Justice Patterson, is really directed to the 4:50-1F issue. But as what I'm saying is that the Tyler decision really embodies that concept, regardless whether it's a taking or not a taking. The concept that someone could lose their property with substantial equity.
But it's a constitutional decision. It's not an issue of, it's not an unconscionability argument. I just want to make sure we're here on a constitutional claim, correct?
Correct. I will agree.
We're not saying that the statute or the previous version of the statute was promoted unconscionable results. It's a constitutional challenge to that statute.
It is a constitutional challenge under Tyler, and the appellate division got it correct.
Amici in support of your adversary say that title companies across the state are now refusing to insure titles because of the appellate division's Rule 450-1 holding. How do you respond?
My response is that my understanding has always been that title companies in general, before this decision was issued, they always would wait a year before they would issue title policy to the tax sale plaintiff, because of the fact that under Rule 4:50-1, as Mr. Greenberg mentioned earlier, is the controlling time period. So there was always that 1 year period where the title companies, to my understanding, would generally not issue titles to the tax sale foreclosing plaintiff.
And if I understand their argument correctly, they're saying that subsection F, which is what you relied on, am I right?
Yes.
Throws a monkey wrench into that because there's no period. There's no end of that.
Well, that was always a concern. I mean, that fact always existed, and somehow they were able to issue policies notwithstanding. It only became an issue when the appellate division incorporated Tyler and said that they felt bound by it, which they rightfully did, and issued their ruling declaring the statute unconstitutional. So I think Justice Rabner mentioned earlier, what was so important? Did the legislature have to act? Yes, they did, because the statute was declared unconstitutional. So the legislature did have to act. And in fact, I believe if I heard my adversary correctly, he said that when a foreclosure judgment is vacated, that the retroactive application of Tyler would be appropriate. So for the same reason, since the foreclosure judgment was vacated and the new law is only supposed to apply prospectively to in cases where no foreclosure judgment was entered, we take the position here that this law applies to my client's case because there is no foreclosure judgment that is presently of record. So he gets the benefit, respectfully, of that new law. And under the circumstances here, I don't mean to ask this rhetorically, but how could this judgment be reinstated given everything that has happened to date? We now have Tyler, we now have the new legislation, and in fact, this court, even before the appellate division ruled, this court, in the exercise of its rulemaking power, issued a notice to the bar in July 12th of 2013, specifically in the preamble, it says in response to Tyler, and enacted new procedures under Rule 4:64, temporarily suspending the Office of Foreclosure's ability to enter judgments in tax foreclosure cases and allowing a property owner to assert as a defense, I have equity in my property, and at that point, the matter would be transferred over to the county vicinages. So this court already has recognized, Tyler, of its impact by making changes to the court rules. This case that we have here is the next logical extension that the court should find that the appellate division's ruling should be affirmed in all respects.
I want to make sure I understand. You're not arguing that the 2024 amendment to the statute is retroactive. You're just arguing that it applies to your client's case because it says that it, quote, shall take effect immediately and shall apply to any tax lien for which the right of redemption has not been foreclosed as of the effective date of this act. And you're saying here there was no final foreclosure as of the effective date in this act because the foreclosure had been undone. That's correct, Justice Wainer-Raptor. Yes. I mean, so if this foreclosure judgment were to be reinstated,
my client would be able to come forward and under your analysis, which I agree with, and be able to say, I'm entitled to redeem because there's been no final judgment entered. So yes, I maintain that that law does apply to my client and further supports and justifies the chancellor's sound decision. And
What is your position as to whether it applies to property owners who had final judgments entered against them and did not do anything until Tyler was decided, and then later filed motions under Rule 451?
Well, Justice Patterson, I take the position that, and I believe this is what our case law says, that each case has to be decided on a case-by-case basis. I don't think
that, but what's your position as to
my position
that category of plaintiffs? Because that affects the scope of this decision.
My position would be that a defendant can never be foreclosed from filing a motion to vacate. Whether the motion is successful or not obviously depends on what the circumstances of that case are. So, but to answer your question directly, I don't think that a defendant should ever be barred from seeking relief from a judgment. There could be all sorts of reasons. Maybe service was improper. I think there's always a.
I'm not saying that that the person who had the final foreclosure order should be able to file a motion to reopen just because of Tyler. You're saying they've always had the right to file a motion to reopen for various circumstances, and they still have that right, not that Tyler has created a new right to file a motion to reopen any closed foreclosure.
Yeah, Your Honor, I think I would agree with that. I think that Tyler certainly fits into the Rule 4:50-1F, and the appellate division properly indicated in this case that it did constitute independent grounds to vacate the judgment, and that decision is correct based on the fact that this was an unconstitutional taking for the reasons we've set forth. There is joint actor contributions here, but by the municipality, and this is, without their contributions, without their signing an affidavit, without their, supplying the redemption figures and collecting the payment, they're really acting like a collection agent. It's not ministerial, with all due respect to adversary counsel. It's much more than that. They're collecting funds and dispersing funds and receiving tax sale certificates and providing them for recording to me. And that's the process that we had to go through. And that's what the statute required. And it is joint action. It is allowing the municipality to do indirectly what it is prohibited from doing directly.
Thank you, Council.
Thank you. I appreciate it. Thank you.
Ms. Martin.
Thank you. I'm here on behalf of Pacific Legal Foundation. Pacific Legal Foundation represented Ms. Tyler before the U.S. Supreme Court, and we've represented a number of similar former property owners seeking just compensation in a number of jurisdictions, including a case that's pending here in the appellate division. The petitioner investor here seeks an outcome that Tyler forbids. The investor seeks a $500,000 property in exchange for returning a $42,000 payment of debt. The investor claims no just compensation should be paid for the difference, but the Supreme Court unanimously held in Tyler that a property tax debt cannot be used as a toehold to take more than what's owed. State law cannot extinguish a debtor's interest in the surplus. That right has existed since at least Magna Carta. It was recognized at common law at the time of the founding of this nation and through the adoption of the 14th Amendment. Tyler held it is a constitutionally protected property right regardless of what state law purports to authorize. The investors attempt to distinguish Tyler by arguing that New Jersey law is different. But as Tyler explains, the government cannot carve out an exception to a rule it recognizes elsewhere. And Tyler noted that Minnesota law recognized equity as a property interest in other contexts, like mortgage foreclosures and executions on judgment. Likewise, here in New Jersey, the law recognizes surplus equity as an interest in those other contexts.
Petitioner, I'm sorry, go ahead, please.
I thought the investor's point was actually that in Minnesota, the state statute had recognized a property interest in this precise exact surplus. And then in 1935, the statute was amended. And so that was the manipulation that the Supreme Court was actually referring to. And that here in New Jersey, there has never been a right in this form of surplus equity. So it's distinguishable on that grounds.
The investor's incorrect. You can find on page 12 of our amicus brief and an 1863 decision called Hopper versus Mallison, a recitation of the history of New Jersey tax foreclosure law. And that opinion explains that previously only personal property could be seized to collect taxes, or timber or other vegetation off the land. In 1852, the state provided that temporary title could be taken and to the bidder who offered to purchase the property for the shortest period of time. In the Hopper case, the period of time was 60 years. The court still found reason to vacate the foreclosure and allow a tardy redemption. But the investor is incorrect. So that this case is on the same sort of footing as the Minnesota case, because the case cited in Tyler is actually an 1800s decision. So it's from a similar era as this 1863 decision. As to whether the investor can be a state actor, the investor overestimates the type of assistance that's required under the joint participation test. In Lugar, the private party simply went to a court, filed a petition, and the court issued a writ of attachment. That writ of attachment gave the sheriff authority to put an attachment on the property. And the property actually remained in the possession of the property owner in that case. And yet that was enough to qualify the debt collector there as a state actor. The Nebraska Supreme Court, as has been mentioned, recently recognized under the Nebraska law, which also involved private lien holders, the lien holders act as a state actor for constitutional purposes. And
may I pause you a second?
Sure.
Before you got to Nebraska, what was the case you were citing about the court issuing a writ of attachment and that being sufficient?
Lugar versus
Okay, that's
Edmondson
Lugar.
Oil.
Okay,
Yeah,
I missed that. Thank you.
Yeah, and the court goes through its history sort of recognizing private parties as state actors. It's not limited solely to the due process context. It's actually for purposes of both the 14th Amendment, which of course incorporates the takings clause against the states, and also for Section 1983, which is how you generally bring takings claims in the first place.
But didn't the U.S. Supreme Court restrict the test in the 2019 opinion, Manhattan Community Access Corp versus Halleck, where it set forward a three-part test when the private entity performs a traditional exclusive public function, when the government compels the private entity to take a particular action, or when the government acts jointly with the private entity. Do you agree that that test controls?
Sure, but the joint participation test is described in greater detail in Lugar, and it's never been overturned. And so I think this is on all fours with Lugar. Again, you get a certification from the government, and then you go to court and you get that assistance of getting your foreclosure judgment and title transferred to you. It's almost identical to the state action involved in Lugar.
Is your test reliant on the benefit to the municipality, the financial benefit to the municipality of the entire tax foreclosure scheme?
Well, I
see what I'm saying?
I do.
Because you could have a statute that where information is required from the state and things have to be done by the state. And I can think of some examples of that without citing them specifically, of statutes that rely on the state providing information. So, but the state really doesn't benefit from that other than it's complying with its statutory responsibility. Here, your argument seems to largely rely on the fact that this is, as the legislature's made clear, is intended to promote payment of taxes and provide a steady revenue stream and, direct financial benefits to the state. So if you didn't have that aspect, would you have a state actor argument?
I'm not sure, but what I can say is that the joint participation test requires that the government has created a right or privilege, and that they're then getting assistance by the government in some manner, albeit minimal,
I think
to get
your
the
adversary
property.
says, though, if that's really the test, then anyone who participates in a court case because a statute allows them to do so could argue the statute has created the right. They then go to court to enforce it, and the court is providing them assistance by enforcing the statutory right. And now all of a sudden they're a state actor.
Well, I mean, first of all, you have to have an actual constitutional violation involved. So it's kind of hard to imagine some hypothetical parade of horribles because we're dealing with a very narrow situation where the government is authorizing the taking of more private property than necessary to pay a tax debt, which Tyler specifically forbids. And that the government is the party that's actually enabling the transfer of that title. It creates the privilege and then it enables the transfer to the private party. So
What if
somebody's
a
liable.
court enforces a contract to sell a property? And the prior owner is claiming that there was something unconscionable about the contract and so forth, and the court enforces it. Does that make the court has no interest in how it comes out? It's not rooting for anybody. It's trying to apply the terms of the contract. Does that make the state a state actor because it is facilitating the enforcement of that contract?
No, Your Honor, because there has to be a right or privilege created by the state.
Let's say there's a statutory claim in the state and a court enforces it. I'm trying to understand the parameters of this argument because it obviously could have very wide ranging effects on many statutes and perhaps many common law claims.
Sure. So it's hard to imagine a hypothetical, Your Honor. It's a lot easier to deal with the actual case that we have here, where you do have something that is most definitely forbidden by the Constitution. Tyler recognizes it. Somebody's liable, whether it's the government or the private party here. To be honest, doesn't matter much to me. But I think that Nebraska handled it very well, holding that the private investors there were liable as state actors. This was on remand from the U.S. Supreme Court in Fair and Naveen. And I think they did so for good reason, for the same exact reason that I'm proposing here today, which is that under Lugar, you have a right or privilege that's created by a statute, by the government. And you have a ministerial act in that case of a tax assessor just rubber stamping, basically, something they're required to do by statute. So I kind of chuckled a little bit internally because they said ministerial. This is different somehow in New Jersey because it's just ministerial to for the
Agree that it's ministerial?
Well, they were arguing that it was ministerial.
No, they were, but you just indicated.
I don't think it matters because
But is it ministerial?
For example, in the Nebraska Supreme Court, they had specifically noted that the government's role was ministerial, but that was enough, nevertheless, to qualify under the joint participation test of Lugar. That the government.
I think you just said that here there's a clear constitutional violation.
Right.
So someone has to pay, and it doesn't matter that much to PLF, but you think that the Nebraska Supreme Court handled it correctly. I thought that I understood your adversaries to be saying that whether or not there is a constitutional violation depends on whether it is the state that is taking the property. Instead, if the state wants to have a statute that said, for example, in private mortgage foreclosure actions, the bank gets all the value and you don't get any surplus back, that would be completely fine because that's about a private bank that holds the mortgage and therefore there is no state action. And so whether or not there is a constitutional violation depends on whether there's a taking of private property by the state, which I see as different from what you're saying, which is assume there is a constitutional violation. Do you understand what I'm saying?
Right, yeah, because the only way that the investor could get this surplus equity is by a statute that created that right, because that it violates that common law right that dates back to 1215. That's recognized in every other context that I have looked into in New Jersey, whether it's in executions on judgment or on mortgage foreclosures or on any other traditional debt collection or the Uniform Commercial Code.
So let's say it didn't exist as to mortgage foreclosures. I know we've established that it does, that the bank can only get the amount they're owed. Let's say there was a statute from hundreds of years ago in New Jersey that said that that's not true and the bank gets the whole value. Are you saying that itself would be a constitutional violation because a statute would say that?
Because a statute would, mortgages are I think, a difficult situation because you're dealing with a voluntary contract between two private parties. Tax collection is not a voluntary contract between two private parties. It is the state imposing a tax upon an individual and then using its power to collect that tax to leverage more. It's using that tax debt as a toehold to take the entire title and then give it over to another private party, which is problematic.
So it's uniquely because it started as a tax debt.
Correct.
But isn't there a piece missing there where the municipality is creating an incentive for the lien holder to take that position? But there's no compulsion to have them actually foreclose on it or attempt to file the foreclosure action. And isn't that the piece that matters in terms of the state action, that there be some compulsion, that there be some additional action on the part of the governmental agency to come to some conclusion?
No, there's no compulsion required for purposes of the takings clause. I think I'm understanding your question as because the investor could just walk away from the investment, would that mean it's not a taking? Is that what you're saying?
But they can simply take back the value at whatever percentage it works out to be without actually taking the property.
Well, I think that's a good argument for finding the investor to be a state actor or to otherwise find the investor liable under some equitable rationale, perhaps allow the government to indemnify the investor, have the investor pay restitution to the government or something like that. Does that answer your question?
The Supreme Court of Manhattan gave 3 examples that can stand by themselves as a basis for a private actor to qualify as a state actor, a private entity to qualify. You focused on joint activity. Justice Noriega just asked you about compulsion. I want you to focus on the first example that they provide, and that is when the private entity performs a traditional exclusive public function. Here, it's not the direct collection of taxes, but the replacement of a stream of revenue for a town for delinquent taxes. Does that overarching theme underlying the tax savings law, the tax sale law, meet number 1?
Is it a public function? I think so, Your Honor. I think, I mean, if you read the Tyler opinion itself, it talks about tax collection as having been the power of the crown in England, that it was something that the sheriff or the crown could itself go take. And then if you look at early American history, and I'm sorry, I don't have a specific case here in New Jersey to cite for you. But if you look at American history, generally, the history is that the local tax collector would collect that debt. Now, at some point that changed here. But I think it is a traditionally exclusive public function. Obviously, only the government can impose taxes.
But the private entity is not collecting the taxes, is it?
I mean, it's still
It's facilitating, it's supporting the existence of a continued income stream in a situation where someone's in default of their taxes, but it's not going out there and knocking on the door, making the phone calls to collect taxes.
It's collecting the taxes plus, I guess, interest, 18% interest, which goes to the incentive question that I suppose I didn't answer fully, which is you don't need the promise of a windfall at the end to incentivize investors to purchase tax liens. And we know that because Florida has a tax lien system where the investors bid down the interest rate to substantially lower than what is bid down in New Jersey, typically the minimum rate, which is a 5% up front and then potentially lower after. And there's no windfall.
Before you even get to that, aren't the private entities here facilitating the collection of taxes in practice?
Yes. Yes, they are. And that is, tax collection is traditionally a government function at Anglo-American law. I would like to touch on the question of retroactivity. Under the Supreme Court's decision in Harper, Tyler must be given full retroactive effect. Harper's rule is simple. If the U.S. Supreme Court applies the rules to the parties before it, then the rule is fully retroactive, regardless of whether the claim is filed before or after the U.S. Supreme Court decision. As Harper explains, the supremacy clause makes that rule mandatory on the states. And
I'm sorry, can you say that one more time? You're saying that as long as the Supreme Court applies the rule to the parties before it and does not hold that it will only apply prospectively in the next case, then it must be given full retroactivity, even non-pipeline, even to judgments that are closed.
right, but I don't think you should worry about how that applies on Rule 450, because what that means, full retroactivity of Tyler means a party can go file a takings claim. It doesn't mean you can go get your title back.
Correct, but a taking claim would involve someone having to pay you back the surplus, even if your house was foreclosed on 20 years ago.
No, Your Honor, because the statutes of limitations are respected by federal courts as well as state courts. And so the statutes of limitations would bar any claim from 20 years ago, as far as I know. Maybe there's some special exception I'm unaware of. But I think 6 years would be the limit here in New Jersey. And so I think that you have to give Tyler full retroactivity. I'm happy to answer questions on that topic, but I would just also encourage the court to take a look at part 3 of our amicus brief, which talks about Harper. Harper is very clear that that it prohibits the erection of selective barriers to whether you can bring your claim based on the timing of its decision. As for, there were a few other arguments that were raised that
Sorry, under Harper, I thought that the actual quote was, when the court applies, quote, a rule of federal law to the parties before it, that rule is the controlling interpretation of federal law and must be given full retroactive effect in all cases still open on direct review.
Your Honor, what that's referring to, and if you read the full opinion, this will become very clear, but what that little qualifier is referring to is whether a case is barred by principles of res judicata, whether it's already been fully decided, the appeal exhausted, and the case is dead. They're not purporting to require, someone filed a takings claim 20 years ago and failed. They're not saying you could then now come and bring that case.
That's not pipeline retroactivity? I'm sorry.
Yeah.
I thought your adversaries were saying if there's a foreclosure action and the foreclosure judgment happened years ago before Tyler, it now cannot be resurrected and you cannot file a takings claim, even under Harper, which is specifically talking about cases that are still open on direct review.
And I'll actually read you the full quote because I think that might actually clarify it. When this court applies a rule of federal law to the parties before it, that rule is the controlling interpretation of federal law and must be given full retroactive effect in all cases still open on direct review and as to all events, regardless of whether such events predate or postdate our announcement of the rule. That predate means you can bring the case, even if, as long as you haven't lost the case already and missed your appellate deadline, you can still bring your case.
So if you're still on appeal, it would apply to, in terms of pending cases, that's pipeline retroactivity, but there could be new cases brought, is what you're saying?
That's right. So for a takings case, you could bring a takings case as long as you didn't already bring one and lose it and miss your appellate deadline.
So that it would only exclude from the very large number of potentially affected cases, though the probably minuscule number of people who happen to have asserted a takings claim and lost before.
Right, yeah, but you've got the statute of limitations and all the usual rules that limit how far back decisions are going to go, and those would all still apply. There's no worry that this would cloud titles. Recognizing full retroactivity of Tyler doesn't affect who owns the property. What it affects is whether just compensation must be paid for the excess property that was taken without just compensation.
So you dispute the amici positions that this is throwing a significant monkey wrench into the title insurance market?
Yes, Your Honor. To the extent that Tyler applies, Tyler does not affect title. How this court interprets Rule 450 can affect title, but Tyler does not affect title. It affects just compensation that must be paid for the taking of a windfall. essentially requiring that windfall to be paid back to the person who it was taken from if they can file within the statute of limitations. There's been some arguments that it would be too big of a problem to allow people to bring their constitutional claims, but this is something that actually happens in takings cases all the time. The government usually argues that the sky will fall if property owners are allowed to bring their takings claims. And I direct the court to Arkansas Fish and Game. We cited it in our amicus brief. An opinion by Justice Ginsburg that said that time and time again in takings cases, the government warns that it's going to impede its ability and that it's going to cause too many takings cases, but the court has rejected those arguments and the sky has never fallen.
Ms. Martin, is there any other issue you wanted to address?
I guess I would say, as far as abandonment, adverse possession, and civil forfeitures, those arguments were all raised in Tyler. The same cases, even Locke, Texaco, Bennis, and the US Supreme Court didn't even bother to respond to most of them in the Tyler opinion, but you'll find them in the briefing. And if you listen to the oral argument, they came up. And they're just unpersuasive. Civil forfeitures involve criminally tainted property, and tax foreclosures are not criminally tainted by virtue of, your poverty or other circumstances. As for abandonment, Tyler also said very clearly that abandonment requires intentional relinquishment and for, quote, a lengthy period of time. And adverse possession is just simply a statute of limitations. Again, a property owner is able to see for many years that their property has been taken from them. At some point, the statute of limitations on their ability to get their property back runs. Unless there's any further questions, we would ask that this court affirm the trial court ruling. Thank you.
Thank you. Ms. Sullivan.
It please the court. As you know, Legal Services of New Jersey is the largest provider of civil legal services for low-income poor people in New Jersey who can't afford legal help. Partly in our 58th year, we were established in 1966. It likely seems obvious, and if so, the obvious is true. Those in New Jersey who have either had or been at the highest risk of unconstitutional takings of their property equity under the New Jersey tax sale law have been our state's most vulnerable and at risk: the poor, the elderly, the disabled, Black, Indigenous, and people of color, the largely voiceless and generally disempowered populations that Legal Services represents and advocates for daily. In ruling on Tyler's applicability to the New Jersey tax sale law, we truly and respectfully urge this court to protect the existing right to 4:50-1 relief and the right to just compensation for all New Jersey property owners, even and especially those who are most vulnerable to takings of their equity and may never seek legal assistance. First, just to frame some statistics. In a 7-year period from 2014 to 2021, $115 million in surplus equity was taken from property owners over and above the tax debt. This was 661 properties in 31 of New Jersey's largest towns. This works out to $174,000 taken per property in a windfall over and above the tax debt. For further context, and based upon the really helpful statistics provided by the New Jersey Attorney General that came from the Superior Court Clerk's office, the vast majority of these windfall takings were committed by third-party investors. For the statistics they provided showing all open pending tax foreclosure cases in New Jersey through April of 2024, 94% were filed by private investors. Further, the statistics showed that the property tax foreclosures are most likely to hit municipalities with higher levels of poverty and existing financial distress. 40% of those open cases were in Camden County and Mercer County. As respondents counsel and Miki have already clarified, retroactivity here of Tyler applies to retroactivity of claims for just compensation, money claims. And this issue of vacating title and marketability of title is not impacted by finding retroactivity of Tyler. Marketability of title and claims for relief under 4:50-1 are separate, and 4:50-1 relief has always been available. So a ruling from this court should not strip away or extinguish the existing rights that property owners have already had. We've seen cases in my office where people have been hospitalized for longer than 3 months, for longer than the time period would take to meet the standard. And it's best left to a trial judge to be able to evaluate the totality of the circumstances in determining whether there are grounds to vacate a final judgment and restore title to a dispossessed property owner. Again, within the totality of the circumstances evaluation. The example here with Mr. Roberto, he had full redemption funds available. Title was restored, and there could be other factors where it's best left to a trial judge to be able to reach the right decision. Further, on the retroactivity piece, as counsel mentioned, they are limited by statutes of limitations. This isn't something where people are going to be held liable going back 20 years or 100 years. This is it's a limited, finite sort of period we're talking about. One of the things that hasn't necessarily been discussed yet today, but I think is important to talk about, is the impact of the ruling on vacant and abandoned properties. This was raised by, I believe, the New Jersey Attorney General and one of the amici on petitioner's side, Invest Newark. Respondents Counsel noted in their brief that this is not an issue directly before the court, and I believe the NJAG also conceded that. But to the extent this court is considering that in the ruling. As amici counsel for PLF stated, the Supreme Court in Tyler said that there must be some intention to relinquish or surrender property ownership. In New Jersey, the Abandoned Property Rehabilitation Act permits a plaintiff to pursue basically expedited in rem proceedings if there is some indicia of abandonment. But the indicia are really, really small and far too subject to mistake to really be enough to say that someone actually intended to surrender their property ownership. So one of the examples cited that meets the indicia is 6 months of non-occupancy of the property and 1/4 of missed tax payments. So we can imagine 6 months of non-occupancy or alleged non-occupancy and 1/4 of missed tax payments could be someone who was hospitalized, could be somebody who's on a work assignment in another state and just wasn't in the property and inadvertently missed 1/4 of taxes. Under what some of the proposals set forth, that would be enough for an in-rem proceeding to proceed. And under the new tax sale law, which we take the position that it is unconstitutional, under the new tax sale law, that property owner would lose their right to just compensation if they didn't take action in a sufficient amount of time.
Now we're really very far afield from this case, obviously.
Yes, Your Honor, but I wanted to address it because it is before the court in some of the briefing, and to the extent this court is considering it in the decision, I wanted to raise these important considerations to be aware of.
Is there anything else you'd like to add?
Yes, Your Honor. So I think the other thing I wanted to just sort of further emphasize here is that I believe the state actor analysis that was asked about earlier under Halleck is correct. And I wanted to actually read a quote from the FAIR decision that sort of ties directly back to the questions that were asked. In applying their analysis and finding that there was a state actor, they looked at specifically the role that the municipality continued to play in the ongoing involvement of the foreclosure by the private investor. And here I just want to note that I'm going to read the quote and I'm going to insert the word petitioner here for what they used as Continental Resources. So they said, much like the private party in Lugar, petitioner, by obtaining a tax deed, exercised a privilege created by the state in order to seize property. Also, like the private party in Lugar, petitioner required the assistance of governmental parties in order to complete its action. Without the municipality's sale of the tax certificate and issuance of the tax deed, petitioner would not have obtained the property.
Citation, please.
This is Continental Resources versus FAIR, and it's.
Page are you reading from?
Sorry?
What page were you reading from in the opinion?
Sorry, one moment, Your Honor. I put the quote in my notes and didn't.
Right, if you can't find it.
Sorry, it's in FAIR, so my apologies.
Counsel, one quick question. Given your office's expansive representation of individuals in a similar situation, would you agree that the circumstances in this case are in fact exceptional?
Yes, Your Honor, I would agree. I believe it is exceptional. The totality of the circumstances that were presented before the trial court judge were exceptional. Unfortunately, most homeowners can't come up with the full money to redeem. They can't come up with the full money to pay the attorney's fees and fully make the other party whole before even filing the motion for relief.
Thank you.
Thank you, Council.
Thank you.
Ms. Riley.
Thank you, Your Honor. May it please the court. If the court decides that New Jersey's tax sale law is unconstitutional under Tyler, it should address one, what entity is liable to pay just compensation, and two, whether Tyler should be accorded pipeline retroactivity. There are good reasons why the court should address each of these now. As the state's amicus brief explains, having to pay just compensation in all cases would have ruinous financial consequences for New Jersey's municipalities. Even uncertainty over which entity is liable would have a huge impact on municipal budget planning. The Nebraska Supreme Court recently decided this purely legal issue for Nebraska's stakeholders, and this court should do the same for New Jersey's.
Ms. Riley, are there not enough legal issues in this case already for the court to address? I understand the importance of this question, but it's not sharply presented to the court. It's not raised until amicus have stepped forward, which usually is not the reason for us to add additional issues.
Your Honor, the issue of who pays inheres in whenever there is a new rule of law announced. It was also you also have the issue has been raised in, it's percolating there, it's been raised in courts below. Without deciding who pays, the court leaves the municipalities just at the mercy of what to do. It's going to.
We wait for another case that sharply presents it and address it then. No?
In the meantime, it impacts municipal budget planning. What do they do? As the Nebraska Supreme Court did.
Aren't they planning based on the new statute?
So, Your Honor, the new statute resolves their perceived constitutional defect, but doesn't fully resolve it. So it says, well, for those cases for which there was no final judgment of foreclosure at the time of the new law. So that leaves a chunk of cases. The battleground is those cases for which there was a final judgment before the new law. And then the question is, should there be pipeline retroactivity, which would say, which is what the state is proposing, which would say, if the case were open at the time of Tyler, there was no final judgment at the time of Tyler, or the case was open on direct appeal, then pipeline retroactivity applies.
So Ms. Martin was just explaining from the Harper decision that pipeline retroactivity in this circumstance actually means that anyone can bring a claim for just compensation, even if there is a final foreclosure judgment.
That is incorrect, Your Honor. What Harper said was that court should give retroactive effect in all cases still open on direct review, and as to all events, regardless of whether such events predate or postdate the announcement of the rule.
Does the first clause modify the second? In other words, you're saying that there are two requirements. One is that it's still open, and the second is the language that you just read?
Yes, Your Honor. And the phrase that you just mentioned there, the predate or postdate, the new rule was ambiguous, and the lower courts differed on how they would apply Harper. So the Supreme Court recognized the confusion and cleared it up 2 years later in the Reynoldsville casket case.
Sorry, and in Harper, you're pointing to the word and instead of or, right? Because it says, in cases still open on direct review and as to all events, regardless of whether such events predate or postdate our announcement of the rule. Whereas if it was in all cases on direct review or as to any events that ever happened, regardless of when, then it would have said or instead of and. Is that your point in Harper?
Yes, and the courts, the lower courts were going back and forth on this. They didn't know what to do. So the US Supreme Court in Reynoldsville Casket versus Hyde, which is 514 US 749, which was 2 years after Harbor, they clarified.
And it's your position that the US Supreme Court has clarified that it is what we would consider in our cases pipeline retroactivity, and does not apply to a group of claimants who have final judgments entered against them as to which there was no pending appeal at the time the decision came down.
Absolutely. And the Reynoldsville court was quite precise about this. It said that new rules must be applied, quote, to all pending cases, whether or not those cases involve pre-decision events. And then drilling the point home, the court said, quote, new legal principles, even when applied retroactively, do not apply to cases already closed.
I think the Pacific Legal Foundation's point there, though, is that this is not about reopening a foreclosure. This is about just compensation. And so someone can bring a separate claim for just compensation, even if the foreclosure was final, and that's always the rule in takings cases.
Yes, Your Honor, and 2 points there. One is that there's another section of Reynoldsville that bears here. And it says there are instances where the new rule doesn't determine the outcome of the case. And it has alternate ways of curing the constitutional defect, which I think is what we have with the new law. And then it also has previously existing independent legal basis barring recovery. And Reynoldsville Casket doesn't mention this, but in New Jersey, we have these independent legal bases barring recovery. For example, the entire controversy doctrine that parties must present all claims and defenses related to the underlying controversy. And just that would be the Kloss case there. And
the way that would work is entire controversy would operate, the entire controversy doctrine would operate to say that if there was a takings claim back in the day when the lawsuit was being litigated, it had to be asserted in that action or not at all.
Yes, Your Honor. And you can just sort of noodle up a lot of different like independent legal bases here. You do have the statute of limitations as well, although as the Klum case said in New Jersey, that can be equitably told. So that's not going to be a hard stop. And you have, things like qualified immunity, things like that. So there, even if the Pacific Legal Foundation were correct, despite Reynoldsville Casket, that full retroactivity were warranted, and it's not, because Reynoldsville Casket made it clear, it still wouldn't mean that full retroactivity would be the answer here because of these independent legal bases.
But it seems to me that this case presents the question of retroactivity, but does not present the question of the impact of the entire controversy doctrine, statute of limitations, et cetera, on individual cases. Am I right about that?
Yes, sure.
What we have before us.
Yes, Your Honor. And if I might switch for a moment, there were a lot of questions from the court with regard to Rule 450 -1. And one spot where the state takes exception with the appellate division's decision is where it seems to say in the last paragraph, it says, well, under Tyler, there was a taking. Thus, it meets, Roberto meets the circumstances of, exceptional circumstances. And I think that is at odds with what this court said in the Hartford case, which is 68 NJ 430 in 1975, that a change in the law is not such an extraordinary circumstance as to justify relief from final judgment under Rule 450-1F. And then that was kind of way back 1975, but in 2003, the court in AB versus SEW 175 NJ 588, reaffirmed that ruling. And
so your point would be that Tyler would not allow someone to bring a Rule 450-1 claim.
yes, the fact that there's a new rule of law like Tyler should not be considered at all in the Rule 450-1 context. And there was some talk here as well about, well, what about the 3-month rule in Section 87 versus 450-1? And it was, I believe someone mentioned it, the Koss case, 178 NJ Super 42, that said that while Section 87's 3-month time limit would ordinarily govern motions to vacate and foreclosure, in the appropriate case, relief can be granted beyond that time. And then you have—
That was an appellate division case?
Yes.
Has a case of this court ever said that?
Not that I can see, Your Honor.
Okay. And that was 178 NJ Super 42?
Yes. And then in New Shrewsbury, which was another appellate division case, it kind of even got more explicit. And it said there's the supremacy of Rule 450-1 over foreclosure actions. And that's 74 NJ Super at 9. I don't have, sorry, I just have the at. I don't have the starting page there.
Anything else you wanted to cover, Ms. Rowland?
Yes, Your Honor.
Abandoned property?
Thank you, Your Honor.
Maybe not too much on abandoned property?
Not too much, certainly not too much on abandoned property. So in light of the United States Supreme Court ruling in Texaco, that owners of abandoned property have no right to just compensation, this court should address the issue. And while the state understands that the court might be hesitant to rule on this issue, in this case, which does not squarely present it, the state urges the court to at least expressly reserve on the issue. Do what the appellate division did not. It just didn't mention it at all, and it leaves abandoned properties up in the air. And if this—
Understood.
Yes, thank you. And Your Honor, you had mentioned before about whether or not the court should address the issue of who pays. And the state posits again that who pays has always been in the context of eminent domain and inverse condensation, whether it's somebody working like the railroads with a direct delegation from the state, or whether it's housing authorities, private parties. The court has always said that it's the person who does the foreclosing, who actually takes the property, that must pay.
Your point is, if what you're saying is that if the claim is that the surplus equity has to be returned, then whoever got the surplus equity has to return it, is your point?
Absolutely. And based on the statistics that we saw, in the vast majority of cases, that is in fact a third-party investor. I think it was like 2,700 out of 2,850 that we looked at in a snapshot. It was a third-party investor. There are some cases there where it is the municipality, and there's even like a rarer subset where it's the state is the one who has gotten the surplus equity. But that comports with basic notions of fairness. The party that has the surplus equity should be the one to disgorge it. If the municipality were forced to pay it back, it would be disgorging something that it never got the benefit of.
Ms. Riley, I say this with an eye on the clock and a desire to get through rebuttal. You amply made this argument earlier on in your presentation.
The state restaurant.
Thank you. Mr. Almanza, I'd like to get through rebuttal. Usually it's a handful of minutes. We'll give you a little extra time. Please go ahead.
Appreciate it, Your Honors. Thank you. First, with respect to the state actor analysis, I want to hone in, Chief Justice, on something you mentioned, whether the municipality's continued receipt of a stream of revenue or a benefit somehow converts the private party into a public actor. I don't think it does, because simply receipt of a benefit doesn't relate to state action. In that case, any taxpayer who pays taxes to the government it would be considered a state actor. Another thing is the joint action doctrine.
I thought the Chief Justice's point was that anything that you're doing to improve collection of municipal taxes could itself be seen as a public purpose.
It's important to keep our eye on the ball here, that we're talking about foreclosure. We're talking about the foreclosure process here. And
that's part of a longer process that exists in order to encourage the payment of municipal taxes, correct?
It begins with the sale of a lien, that's correct. But again, we're just talking about the alienation of a property right by a state government.
It's facilitating the collection of taxes, a traditional exclusive public function addressed by prong one, example one in Manhattan.
No, because it's never been. Since the beginning, the government has always relied on private parties in this regard. So for as long as tax liens have existed.
That doesn't mean that it's not facilitating the collection of funds, though, does it?
It means it's not exclusive, because they're relying on private parties.
You're suggesting that tax collection is not an exclusive function?
No, tax collection in and of itself. But the foreclosure is what we're talking about here. The foreclosure is not. Unless it's being prosecuted by a governmental entity, there is no governmental involvement in a private tax lien holder foreclosure. All of the actions that the lien holder takes are of its own behest, of its own accord. It doesn't get assistance. It doesn't. All the things that were cited as here's examples of why there's intertwinement, those are things that happen outside of the tax foreclosure context. Collecting taxes, issuing redemption sheets, those are things that happen outside the foreclosure context as well. They don't.
You're saying these are not exclusively foreclosure functions?
Correct.
Because the municipality would be required to provide the information, whether it was to the property owner or to the party seeking to foreclose,
or to a mortgage, or to a mortgagee, or yes, correct. Exactly.
The mortgagee in that circumstance would only be entitled to the money that it was owed, not the surplus, correct?
I'm just referring to if a request was made by a mortgagee for a redemption statement so they could pay a delinquency of their mortgagor, then yes. That's what I'm referring to. Continental versus the Nebraska case. Want to draw a very clear distinction here that really I think is elided by the other side. The county is involved in the transfer of title. The county treasurer issues the tax deed to the lien holder in the absence of court process. That is not the system. It's never been the system we've had here in New Jersey. That alone should render the state actor analysis of Continental unapplicable here, inapplicable.
So you're contending that when your counsel for the amicus, Ms. Sutherland, substituted petitioner into that holding, it was not a fit.
It's not an apt comparison, simply because the law works differently there. There is governmental action in Nebraska with tax foreclosure. It's not the way it is here. Justice Noriega, compulsion, you mentioned compulsion. No compulsion. That is one of the elements.
Is it an element or is it an example of many?
It's a circumstance in which state action can be found.
But that one doesn't apply. We shouldn't focus on it. But it struck me as I read Manhattan, it did not set up a three-part test that was conjunctive.
It's not an element test, really. It's any of these circumstances can result in state action. Correct. With respect to retroactivity, I agree with Ms. Riley. I think she put it very well. Reynoldsville Casket clarifies Harper. Again, Harper says all cases still open on direct review. We already have a court process that has adjudicated the party's rights with respect to a particular piece of property. So to come back then years later and say, oh, hold on a second, we now want to assert a claim with respect to that property shouldn't be permitted. That's not what pipeline retroactivity calls for. That collapses pipeline and full retroactivity into a single thing. And lastly, with respect to the property right, I heard a citation to a case, an 1860s case, about how we did recognize at common law this right to surplus equity in tax foreclosures. This precise issue was actually raised in a case I cited called Mitch v. Owens. It's a 1913 Chancery case where the property owner said, I should be entitled to a sheriff sale, a foreclosure sale, identically as if it were a mortgage foreclosure. And the chancellor said, no, you're not. That's not the way that the law works. It's not the way the law has ever worked. So I think that case really disposes of the notion that we had some sort of history in this state recognizing the right. Unless the court has any, oh, the last thing I want to leave the court with is, please keep in mind that this court back in 1964 in Braun v. Weintraub, it gave its imprimatur, it gave its blessing to strict foreclosure. It's dicta, yes, I recognize that, but municipalities have labored under the apprehension for many, many decades that this law is valid, legal, and especially with respect to the strict nature of foreclosure, which is what's at issue here. This court said it was understandable, that's this court's language, that the legislature opted to bar the right of redemption by strict foreclosure. So please
What's that case again? I'm sorry.
Braun v. Weintraub. It's a 1964 New Jersey Supreme Court case.
Do you have a cite for that, please?
I can get one real quick for you.
Is it in your brief?
Is it in your brief?
42 NJ, yeah, it's 42
Thank
NJ. It's in my brief. Sorry. I just, so please keep that in mind when the court is considering retroactivity. I would appreciate that. Any other questions?
Counsel, thank you for the focused rebuttal.
Appreciate it.
And thank you to all counsel for the evident preparation that went into this. Very much appreciated. Court will be in recess for 30 minutes.